morning, Ms. Law. Good morning, Mr. Bodlani. Good morning, Advocate Johnson. Thank you.
Morning, Chair, morning, Commissioners, and good morning, Advocate Johnson. Advocate Johnson, when we adjourned yesterday, you recall we were having a conversation about the teams within IDAC. And I think you were explaining that you have permanent teams in some instances, and I don't remember whether now that's my deduction, that sometimes you have ad hoc teams, but if that's my deduction and I have my, if my understanding is wrong, please feel free to correct me. You gave an example of what you call the Transnet team. So we're discussing how they get to be constituted, and hopefully that will lead to the issue of whether or not any particular powers you have are delegated to such teams, if so, which powers, and if so, further, in terms of which prescript such delegation happens. The idea, of course, being once you have taken us through the permanent teams, if you could cover the ad hoc teams and how those are constituted, when they are constituted. Of course, the idea being to eventually get to understand in the matter that we colloquially refer to as the Mokwele matter, where that team falls. Is it a permanent team or an ad hoc team? I'll leave it to you to clarify to the commissioners. Thank you.
Good morning, Chair. Good morning, Commissioners. In terms of the teams, there aren't ad hoc teams. There are teams across the board dealing with different matters. However, what you can do is take people from different teams to constitute a team to deal with a specific matter. At the moment, they are specific teams based solely on the many matters we had received from the State Capture Commission of Inquiry, the Party Commission, the Nugent Commission. And so once a team became vested with a matter, all other matters related thereto invariably went to that team. All prosecutors have the power to institute and conduct criminal proceedings for and on behalf of the state. And so those powers find themselves in Section 20 of the NPA Act. And prosecutors are then so delegated to conduct, institute prosecutions and matters incidental thereto, Chair, as a result of them being prosecutors within the NPA. In terms of the investigative powers, the powers are derived from Sections 29 of the NPA Act, the NPA Amendment Act, which allows for the investigating director 29A, 1, an investigator may, subject to
just a correction.
Apologies.
It's not of the Amendment Act. That's been inserted
into the main Act.
Into the main Act. So
Correct.
it's Section 29, uppercase A of the NPA Act, not of the Amendment Act.
As you've correctly pointed out. But what it does do is then give investigators powers to deal with aspects of investigation subject to the control and direction of the head of the investigating directorate. And so they exercise such powers and must perform such duties as are conferred or imposed upon him or her under the Act and or any other law, and must obey all lawful directions which he or she may receive from a person having authority to give such directions. And an investigator under subsection 2 has the same powers as a peace officer or a police official, as provided for in the Criminal Procedure Act. And they, therefore, in terms of that section, have the power to investigate offenses, the ascertainment of bodily features of an accused, powers of entry and search of premises, the seizure and disposal of articles, arrests, the execution of warrants, the attendance of an accused person in court, and the service or execution of any subpoena or summons. And 3, an investigator has the same powers as if he or she had been appointed deputy sheriff or deputy messenger or other similar officer of the court. So they do derive their functions from the legislation and are therefore delegated to exercise prosecutions for prosecutors, investigations with the investigators.
What we see from sub 1 is investigators exercise their powers subject to your control and direction. They're not free agents who go about making decisions, determining what to do in a manner or in circumstances where you have no say over what they do and how they exercise their powers. It's subject to your control and direction.
That is correct.
Yes.
Thank you, Commissioner Balo. Thank you, Advocate Johnson. While we are on this topic of teams, in the investigation conducted by IDAC that culminated in the arrest of General Khumalo and others, just so we can bed this one, what was the constitution of the team? Which team was responsible for that investigation and subsequent prosecution? And are you able to name the key members of that team, be they investigators or prosecutors? We learn, at least from Colonel Padiachi, that he was the lead investigator. So if you could assist us in populating the rest of the team and to indicate who was the leader of that team. I'd appreciate that. Thank you.
So when the matter had initially come to IDAC, the matter was allocated to we chose a group of prosecutors that fell under the leadership, or the prosecutor was Advocate Ramsamy and Advocate Joy Hlachwayo. And it was
between the two, who was the lead?
When the matter first started, Chair, it was Advocate Ramsamy who led, and as the matters progressed, each one of them led a matter so that they were able to carry the burden of that matter. So Advocate Joy Hlachwayo is the one who went to court on the Mokwele matter. Advocate Ramsamy would have been the one who went to court on the first matter, which was with General Lushaba and others. But they would go to court together, and either or having to deal with the matter as they dealt with it. And then, Chair, we had Chief Perumal, Mr. Belochin.
Sorry. When you mention a name, please indicate what role they played. So Chief Perumal played what role?
If you just grant me a moment just to get my paper, Chair, so that I'm able to guide properly. Mr. Perumal is a chief investigator and would have helped lead and coordinate the team of investigators, obviously under the leadership and guide of the prosecutors. We had Mr. Rapesu, who is also an investigator. We had Mr. Padiachi as an investigator. we had Mr. Wessels as the chief financial investigator. We had,
And between Mr. Rapeso and Colonel Padiachi was on the Mukwele matter, and Mr. Rapeso was on the Lushaba matter, or not?
that is correct.
All right,
When they started, yes.
Okay,
But
all right.
that allocation gets determined amongst themselves on
Yeah.
who would lead which, but you designate the team to the investigation.
No, I just want to get the facts. I
Thank
just
you.
want to get the facts. Yes.
Sorry, and then we had Mr. Patam Lambu as an investigator. And in all the matters, we do have a project manager. And in this instance, the project manager was Mr. Tlale. There was a deputy director as well.
Sorry, apologies, Advocate Johnson. Did you say Tlale?
Tlale,
Missed it. Okay. Thank you.
T-L-A-L-E, Mr. Tlale.
Absolutely.
And what role did is it Miss or Mr. Mlambo?
Mr.
role?
Mlambo is an investigator.
No, I heard that is but what I want to know is, basically, as I understand it, there's the Lushaba matter, there's the Mukwele matter, and I asked you whether between Mr. Rapeso and Colonel Perumal, one was investigating one of the two matters, and you said yes. So I want to know about Mr. Mlambo. Where did he fit in?
Mr. Mlambo, as part of that team, would have dealt with whatever taskings they gave him,
Okay.
not necessarily only Lushaba or only the Mokwele matter.
Thank you.
The team would have determined the taskings and who was best to deal with that investigative task.
Thank you, that answers me, thank you. Any other role play?
There was Advocate Manilal, who's
Did
sorry,
you
Chair,
explain about Ms. or Mr. Tlale?
project manager.
Project manager. Okay, you have quite a structure there. And then who else after?
And Mr. Manilal, who is, as I indicated yesterday, Chair, all the teams are led by deputy directors of public prosecutions, and that would have been Mr. Manilal. At a stage when the matters first started, because Mr. Manilal was busy in court, I think with the Transnet matter, on a informal basis, we did have Advocate Peter Sarunye, who would accompany the prosecutors to court, so that if there was anything, he was able to engage the office and to indicate if there were any challenges. But
Is he also DPP?
He's a DDPP, yes, ma'am.
I just want to understand this. I've always understood DPPs to be attached to, not necessarily part of, but let me loosely say attached to a particular court. Like, for example, you would have a DPP for the Gauteng, in the sense of Pretoria High Court, then another one in Joburg, another one in Tata, and so on and so on. So when you talk about a DPP in this context, are you...
Sorry, DDPP, Deputy Director.
Also, they are DPP. So Mr.
Manila is a Deputy Director of Public Prosecutions.
Deputy.
Yes, sir.
Now I understand. Thank you. I did not hear the deputy. Sorry.
When you started, you mentioned the name of Bello Chan. You haven't mentioned him as you're listing now, the specific list. Is there a reason for that?
I just want to check, Chair. I might have misspoke. I want to see the document in terms of the later. No, my apologies, Chair. I misspoke. He's not in these matters.
Thank
My
you.
apologies. He's in the Matlala matter.
Thank you.
Is that the makeup of the team?
That is the makeup of the team.
I think,
at the
I
time.
think the mention of Mr. Beluchan, I forget the rank, was in your affidavit, am I mistaken? Was it not in your affidavit? Where did I see it? Where would we have seen it? You don't remember? Oh, no, please look, please look. I'm asking because...
The mention, Chair, is because he was the person who had gone to Otia to inform General Khumalo that there was a warrant of arrest.
Oh, that was the context.
That was the
That was
context.
the context, in your affidavit?
Yes.
Okay, all right.
But that he would have gone there must mean he was part of the team in some capacity.
So when they execute arrests and or search and seizures, different people can form part of the execution teams. They must be put onto the application for the warrant of arrest or for the search warrant. It is there that he comes into play. There were other people as well that were involved that are not involved in the investigation. You can become for that specific purpose. Chair, I just wanted to indicate, if you'd allow me, the names that I gave you were the names of the team shortly after we had received the Section 27 referral and we had the preliminary investigation authorized. As the investigation progressed and just before the arrests, there was an application for a Section 28(1) full investigation in terms of the NPA Act. I would just like to check if other names were subsequently added so that the Commission has the full ambit of who all, other than these, were then involved in the matter.
Oh, please go
Yes,
ahead.
there are persons that then became, I had mentioned, chairs, that it was Advocate Manilal, I mentioned Advocate Ramsamy, I mentioned Advocate Joy Hlachwayo, I mentioned Chief Investigator Perumal, Investigator Beluchan, Chief Financial Investigator Venant Wessels, Investigator P. Mlambo, and then we have Investigator Charles Eales, E-A-L-S, and Investigator Ayanda Mbalo. They came in later into the team.
Sorry, now I'm confused. So Beluchan did become part of the investigation team. He didn't just go to the airport to inform General Khumalo that there is a warrant for his arrest.
No, he did not become part of this investigation team. He's not of the people
But you've
designated to the...
You've just included him in the post-Section 28(1) process. You say there was a Section 28(1) application for preliminary investigation. You
Yes.
say that. And then you proceeded to list who, arising from that, became part of the team. And you say Eales, you say Ayanda, and then you said Beluchan.
No, it's Charles Eales and Ayanda Mbalo.
You just...
Did I? Apologies, I think
Unless you want to exclude him, you did mention him.
My apologies. It is on my document that it is Manilal, Ramsamy, Hlachwayo, Perumal, Padiache, Wessels, Mr. Mlambo, Mr. Eales, and Mr. Mbalo.
But you seemed to be reading. You were looking down and you seemed to be reading.
I'm
Surely
yeah,
you...
I'm prepared to show this through
Oh,
council
okay,
to...
okay.
Yes, that
How did you vocalize the name then, looking down as if you were reading it from a list? How did you come to vocalize the name?
I don't know why I said his name.
Okay, all
Sorry.
right. No, it's okay, it's okay.
The section of your affidavit, Chair, was referring to, good morning, Advocate Johnson. It's
morning.
paragraph 13 of the original affidavit, where you list Messrs. Sunil Beluchan and Ayanda Mbalo as the investigators.
As the investigators who went to the airport and would have been authorized in terms of the warrant for execution.
But
That-
why do you
that is
call them
him.
investigators if all they are doing is execute the warrant?
Because that is their designation, Chair.
But their role is that of investigators,
Yes.
their normal role.
Yes, investigators executing a warrant of arrest.
Okay.
Thank you. I think from yesterday.
Sorry, before you go
absolutely,
on,
Chair.
before I just, you'll remember yesterday when I even expressed myself in Afrikaans saying that.
Ek is deur mekaar.
Klaar deur mekaar. When you responded to me about whether or on whether Colonel Padiache had ever had sight of or received the Section 27 referral affidavit, my distinct impression was that you said, yes, he did. But when immediately thereafter Commissioner Baloyi engaged you, my sense was then that you were saying the opposite. I'm not sure as I sit here what your final position is on that. I just want us to put that to bed. Did he or did he not receive that Section 27 referral affidavit?
Chair, as I undertook that I would get clarity
Yeah.
from the team, he did have sight of the Section 27.
He was given, in the sense of being given.
He had sight of it. That's the answer I have.
You see,
So-
you may have sight, in the same way as, for example, police officers will flash their ID cards, just like that. Or you may have sight in the sense that you are given the document, you read it, you internalize its contents. So was he given that document for him to personally read and internalize its contents?
So initially, he would have had sight of it, and later in the year, when he had all the dockets.
No, explain having sight. That's what I'm interested in. What do you mean by that?
That when the team met, they engaged the 27, and he is part of that team.
No. That doesn't answer me. What do you mean when you say he had sight of it? Surely you understand the essence of
He saw the document.
seeing, as in here's a document, it's lifted, and he does see it if it's lifted like this. But if it's immediately put back on the table, it's as good as not having been seen by him. So what do you mean by he did have sight of it?
So I'm giving you I'm giving you an explanation I get because I'm not inside of that room.
That's far you have not explained. That's why I want, what do you mean when you say he had sight of it? You have not explained it.
He saw the document.
I want to understand seeing. Is it in the sense of it being flashed? Here's a Section 27 referral affidavit, boom. It's gone back to the top of the table and he doesn't see anything. Is that what you mean by seeing? Or do you mean it was given to him for him to peruse it for himself?
He was given the document to peruse for himself, according to him and to the team, much later
That's
on.
all I wanted.
Much later on.
Sorry, or much later?
Much later on.
At what stage was that? At what stage was that? Was this before he started investigating, or was it after he had commenced investigating? If it's the latter, that would mean his investigation was not informed by the affidavit. So you say after he had commenced
After he had commenced.
investigating.
That is
so
correct.
after the Section 28 investigation had commenced.
Yes.
All right. Thank you. Now that answers me. And the Claude Diermekar is gone.
And apologies, but it is answers I had to seek because it's
Yes.
not my direct knowledge.
Yes,
So if I
yes.
didn't convey it correctly. I do apologize, but it's the answer that I was given.
No, as I said yesterday, hearsay evidence is admissible in this commission. There's authority that says a commission of inquiry of this nature may inform itself in whatever manner it wishes to. The only issue, depending on the nature of the evidence, would be the probative value of such evidence. Thank you.
Thank you.
Did they say exactly when? Because in your response to the chair, you said later in the year. Now that worries me because the arrests were mid-year. So if later in the year is after the arrests, that is a problem. So when you say later in the year, what do you mean? Do you mean after June or before June 2025?
It would have had to have been before June 2025 because he became the investigator earlier on, which was
In January?
in January.
Yes.
Yes.
Yeah, I don't think it's an answer that that kind of question where you answer, it would have been. You have had opportunity to ask, and you were told you saw it later on. You either did ask and were informed when later on, or you must still go back and find out when exactly did he see it, because the way you're answering, you don't have personal knowledge of it, so you have to check with other people, and we shouldn't be left with the impression that yes, he saw it before the arrest because of how you've answered. I think it's a question that you must verify and come back to us with a specific period.
I will do that, Commissioner Baloyi, with the exact answer.
Finally, do you dispute his version when he says before this commission that he did not see the Section 27 affidavit? Do you dispute his version? Do you say he's not telling the truth?
I'm unable to dispute his version because he's in that team. That is why I'm saying I have to ask the questions after the fact.
Thank you.
It's not my place to say he lied. He would have to, he explained as he did, yes.
Thank you. And thank you, Advocate Johnson.
Mr. You're still going to be discussing the Section 27 notice. I do have a question, but if it's a topic, you are still going
Section
to cover.
27 affidavit.
Affidavit.
Yes.
Okay.
We're still going to.
All right, I'll leave my question for now.
Thanks, Commissioner. You gave this it's quite a big team. You informed of, I think, Ayanda Mbalo, Charles Els. From yesterday, you keep referencing Chief Perumal. Chief is not his name, is it?
No, it is the rank. He is Dylan Perumal.
Dylan, thank you. Now, you now have, as I understand, a group of prosecutors. Well, the prosecutors, there are two, and then a group of investigators. Who leads then this entire team? Who's the leader of this particular team?
It is the Deputy Director of Public Prosecutions who leads the team. And then within the team, you will have, as you have a chief investigator who will lead the investigative part of the investigations. But the team is led by the Deputy Director of Public Prosecutions.
Okay, and in this case, that would be Mr. Manilal.
That is correct.
That is the leader of this team,
Yes.
not Chief Perumal.
No.
Because I understood Colonel Padiache to refer to Chief Perumal as the leader of the team. Was he perhaps wrong in your understanding?
Not wrong. I think as an investigator, having the chief criminal investigator in the team, they look to him as the leader of the investigations. They almost invariably engage with him in terms of the taskings and the activities, reporting back and getting guidance. The everyday investigative functions would be dealt with by the chief criminal investigator or a senior investigator, as is the case in other teams as well.
So then what's the role of the leader of the team? What is Mr. Manilal's role as leader?
So Mr. Manilal's role is, because IDAC has a prosecution-led investigative methodology, they have to sit together to work out what the prosecution strategy is, what investigations must take place. They look at the resources that may be required, and so what his role is to coordinate and direct the evidence that will be, investigation that must be undertaken for the evidence to be collected and the relevant evidence that would be required. And then there's that constant to and fro as things come in, perhaps to look at the legal prescripts. Have they been met? Are there things that are outstanding? And that is the guidance, et cetera, within the team, both of the prosecutors and investigators.
So then, in this team led by Mr. Manilal, who gets to decide whether the Section 27 referral is distributed to members of the team? Who makes that decision? Is it Mr. Manilal as the leader, or who is it?
Ordinarily, it should be the team leader, which is Mr. Manilal, but it would depend on who had the document at the time. There's no rules about who gets what and who decides who gets what. I think it's a...
What's the purpose of being a leader?
No, I see.
So
where you're
sorry,
going to.
you spoke at the same time.
I apologize. The error was mine. I apologize, Chair.
Apologies, Chair.
Yeah, please finish what you were saying. And
What it is you have the team leader who will decide what all must happen. So obviously, invariably, it's the team leader who should distribute all the documents. I don't know that there's a decision who to give and who not to give. It works in terms of what is required at the time and who's the person who should have access to the document. You may find that it is a prosecutorial document and not necessarily something you need to distribute at the time to everybody else. So they will work it out amongst themselves, who gets what, when. But there isn't a prescript or any rule that says or precludes anyone in the team from not having access to documents in an investigation.
Okay, let's come back to the Section 27 affidavit. Who decides between between you, Mr. Sissoko, Deputy Director Manila, Chief Investigator Perumal, of the four of you, who decides that Colonel Padayachi, as the lead investigator, will or will not have the Section 27 affidavit? Somebody makes that decision. It's not a team decision.
No. Once the document is, after Mr. Sissoko and myself have gone through it and we decide falls within the mandate, we give it to the team leader.
Team leader here is, because we've got two people now. We've got Deputy Director Manila and Chief Investigator Perumal. Who is that team leader?
Is Mr. Manilal.
Mr. Manilal.
Is the team leader, yes.
So he's the one that decides whether or not the investigators, and when I say Colonel Padayachi, also Rapesu, because you say Rapesu is in the other matter. So it's Chief Manilal who decides.
Advocate Manilal, yes.
Advocate Manilal who decides whether or not the investigator should have the Section 27 affidavit. Thank you.
Thank you. Before we leave this topic, you were reading off some documents and you reference a preliminary investigation authorization, and the second is an application for a Section 28 sub 1 investigation. You seem to be reading from documents. And from my recollection, those are part of the documents that we had requested in terms of the subpoenas issued, but we unfortunately don't have at hand. As you look at them now, could you provide us the date for the preliminary investigation authorization from the record you have in your hand? What's the date of that?
Apologies, has the documents not come through to the Commission?
Is that the lot that was coming in through this morning? If it was coming in through this morning, it has to make its way through the system, so it will eventually get here. That's fine.
Mr. Botlani, are you able to assist on this?
Yes, Chair, I am. As I understand it, it is part of the documents that were made available this morning. It may very well be that it is yet to find its way to my colleague, but as she says, there is a system, and maybe it has bottlenecks here and there, but it's part of those documents, yes.
Thank you, thank you.
Thank you, Chair. Then we shall be sorted latest by T. They'll be printing. But in the interim, can you give me the date for the preliminary investigation authorization?
6 December
Yes.
2024.
And for the application for a Section 28(1) investigation?
Would have been 30 May 2025.
2025. Thank you. This detail and this structure helps. Now, we've been talking a lot about the Section 27 referral in the Mukwele matter. This, as in file 2, page 512, it's CJC 373. Page 512. I need you to keep open that file for the moment. There is another document I would like us to have at hand. It's from General Mkwanazi's annexures, MK 1616.
So look, this is the information note.
MK 1616. It's a letter from the Office of the Minister of Police.
Yes, sorry, I was in the wrong tab.
Okay, thanks. Chair, I think we have a spare copy of that. It's being availed to you now. MK 16 would start at page, paginated 310 in that bundle. Thank you. Let's start with MK 16. If you look over leaf, it's dated the 11th of November 2024.
Correct.
Yeah. And if you just like cast your eye at page 516 of the file 3 that you have opened, the referral that is dated the 21st of November 2024. So let's follow the events sequentially. And I think you did reference this document that is marked MK 16, which is a letter signed by, it would appear, the Chief of Staff, Ministry of Police, Mr. Ngabinde, and it's directed to the investigating director, yourself. And it shows as a heading, referral and request for investigation in terms of Section 27 of the National Prosecuting Authority Act 32 of 1998, read with the National Prosecuting Amendment Act 10 of 2024. You confirm receipt of this letter?
Of the MK16.
Yes, ma'am.
Yes.
And this letter purported to refer to your office, complaint by Mr. Adams, a member of parliament, and concludes overleaf with the following statement: Honorable Fadil Adams was advised by this office to await your decision in this regard. You see that?
I see that.
Now, kindly inform the commissioners what you did upon receipt of this letter.
This letter came to us by hand, and it didn't have any attachments to it. I looked to see if we did even reply to it. I can see the letter come in, but we don't have a response to the ministry acknowledging receipt of this letter. And it is afterwards that we got an envelope that was delivered to the office with the 27.
No, we'll get to the
As it is,
27.
yes.
For the moment, let's stay with this letter.
Yes, ma'am.
Did you act upon it?
Sorry, I didn't hear.
Did you act upon the letter? There is a specific request there to look into the complaint by Mr. Adams in respect of the cases listed there. And, as I say, at the end, to inform Mr. Adams of your decision. Mr. Ngabinde says, Honorable Fadil Adams was advised by this office to await your decision in this regard. So I want to know, upon receipt of this letter, what steps did you then take? You have clarified that you cannot find a response to this letter, nor an acknowledgement of receipt.
And could not act on this letter because there were no attachments to it.
No, what you're being asked is that last paragraph says, Honorable Adams was advised by this office to await your decision in this regard. And the question is, having received a letter from the ministry, what did you do? Not did you institute an investigation? Was it a letter sufficient to act on it? That's not the question. The question is, you have correspondence directed to you. I assume you do not just file away letters when they come in, especially where you are told that the complainant is awaiting to hear from you. The question is, what did you do? Either you did nothing and filed this away, or you did do something about it. And you have to say, what did you do?
What I would have done, and that is why I'm saying I cannot find it, we would have acknowledged receipt of the letter. And that is as far as I would have been able to take it, because there was nothing to do. There wasn't anything attached to this letter for me to be able to act upon it.
That's not an answer. Surely that's not an answer, Advocate Johnson. You cannot just acknowledge receipt and then keep quiet. How will the ministry know what your issue or problem is? Why not raise it with the ministry that I'm not able to do anything with this because, as you put it, there are no annexures to your letter? Why do you just acknowledge and then fold your arms and do nothing? That escapes me.
Not do nothing.
You've just told us, that's far, sorry. Thus far, you've basically told us that you did nothing. All you did was to acknowledge receipt of the letter.
Yes.
What did you do then if you did do something? What did you do?
I honestly cannot remember. I have to cast my mind back to, in the acknowledgement of the receipt of the letter, I speak under correction. I'm not sure that I asked and indicated that there was nothing attached to this letter, because a few days later, by way of envelope, we get the section 27.
He would have been told to file a section 27. I mean, he didn't make it up. He didn't wake up one morning thinking, oops, I have to put in a section 27 affidavit. So someone would have advised him to file that. That's why it's important to know, what did you do? What did you say in that acknowledgement of this letter? You must have said something before we get to, you then received an envelope.
And the acknowledgement would have been typed from an internal computer. Surely you have that letter in your possession or a draft of it somewhere in the computer, and it can be made available to the commission.
We have looked for it. I'm going to ask them to look for it again, because I also have to apply my mind. I can't, that is why it sounds like a fumbling answer, because I can't recollect what I would have written over and beyond. We acknowledge a receipt, and in all likelihood would have alluded to the fact that there is nothing there, because it talks to this envelope coming with the 27 a week later.
But you see, speaking for myself, Advocate Johnson, the answer you've just given now creates an impression that a draft of this letter was deleted. That's why it's not available, because you use a laptop to draft a letter, and then your PA, I assume, would have then either printed it from that computer or emailed it to you. And if you are happy with it, you would have appended your signature, and it would have gone to the minister's office. Now, if you're saying we have looked and it's not there, the question is, what would have happened to that draft, unless somebody deleted it so that it is no longer available?
And maybe to correct what you've said, this letter doesn't say, here's a copy of an affidavit. It says a copy of a written correspondence addressed to the minister. So if it lacked anything, it was the letter which Mr. Adams addressed to the minister, not an affidavit. You still have, you're not on suspension. You have your laptop. You are able to check this and give us a copy of your response, right?
Correct.
Okay.
And I will look for it again. I will have the PA look for hers again. We did try that exercise, or we did do that exercise, not try the exercise. But if you give me till lunch today, we'll go back. I'll ask the IT, perhaps, Advocate Maga, if we could just engage with the IT to check through the email correspondence of both myself and my PA. It could have been I drafted a response and emailed to her, or she would have an emailed to me, so that we are able to give the commission a full account.
From what you're saying, so it means the letter should be in both your inboxes.
Should.
Your PAs, maybe on your side, if you send to her, it will be on your sent items, and then in her inbox. If she drafted it and sent it to you, it's in her sent items and in your inbox.
Correct.
So again, going back to what Commissioner Khumalo said, it's unlikely that it would disappear.
No.
on both ends. That's just unlikely. Do you agree?
Correct. And if I may, just one point of correction is, there are times as well, Chair, where I would type a document, print it myself, sign it, and then hand her the hard copy to distribute.
Yeah, I was
just for purposes of clarity.
You are correcting yourself, because what I suggested to you now was based on what you had said, which was you sending or she sending, or he, because your PA could be a he, or she, yeah. So I was basing it on what you had said, but you are correcting yourself and now saying it could be on one end only.
Correct.
All right, okay.
Sorry, there was a question by Commissioner Baloy that got lost in this engagement, which was, how else would Mr. Adams have known to contact IDAC and prepare Section 27 affidavit? Did IDAC contact Mr. Adams and say, we need an affidavit from you? Because this is 13 days later, so the minister's letter is the 11th of November. On the 21st, so it's about 11 days, 10 days, Mr. Adams then has this affidavit. I don't know how it gets to IDAC, but how did Mr. Adams know that he must do a Section 27 affidavit for IDAC?
Mr. Adams would have had to be contacted by IDAC.
Following upon receipt of this letter, IDAC contacted Mr. Adams.
IDAC would have had to have contacted him, yes.
Who did that? Who contacted Mr. Adams?
In this instance, it would have had to have been Chief Criminal Investigator Perumal.
Do you know for a fact or don't you?
I did, that's why I say it would have, in all likelihood, would have been Chief Investigator
So
Perumal.
you don't know for a fact?
I don't know for a fact.
But why do you think him?
Because later on, the engagements with Mr. Adams were with Mr. Perumal and the other investigators. We would not have then sent people that have not already engaged with him.
Sorry, Ms. Law,
Indeed, Chair. No.
it was your question we took over. So
No, it's following, these are follow-up questions to your question I had asked, so it's very, they flow from the question. I'm happy. Please, Chair.
Please go ahead, please go ahead.
Can I ask on the back of that, your response, the way that I've understood your description of how your processes work, it's you get a Section 27, you then discuss it with, you take a view, you then discuss it with Mr. Sissoko, you give it to him to then take his own view, the two of you agree something, and after you've agreed that there is an offense in this referral, you then refer it to the team, right? That referral to the team, who in particular does it go to from you and Mr. Sissoko? Who does it go to? When you say we then refer it to a team?
The office would usually call the project manager to hand over the document, and then it goes then into the team for the deputy and all of them to work through the document.
So is Mr. Tlale a forever standing project manager? At that point, it's you and Mr. Sissoko. When does a project manager get appointed to be responsible for this now?
It depends which team you're sending it to. They have standing project managers.
So there was already a team to which you referred yours, and I'm going to call you the intake committee for now, until you have that discussion with Ms. Sillo and the rest of us. But for purpose of our discussion, you are the intake committee. You've made a decision. Is there a project manager already at that point, or do you then proceed at that point to appoint a project? I'm just trying to understand how you then process it from that point. And we'll come back to the question about who contacted Mr. Adams.
There are 4 project managers in the office. And when you allocate a matter to a team, that team already has an existing project manager. So it is, the project manager may have been there because of other matters. And like I said, for example, that team deals with the Transnet matters under Mr. Manilal. So when we gave the matter to Mr. Manilal, the project manager who's been in that team is Mr. Tlale.
Okay. Now, if Chief Perumal is the one that contacts Mr. Adams following this letter, where does he get that from? This is Chief Perumal. Where does he get it from that he must contact Member of Parliament Adams? Because at this point, there's no Section 27 yet that has come in. So that process of you and Mr. Sissoko hasn't yet happened. nothing has yet been referred to a team or to a project manager and team. How does Chief Perumal come into it? After you've received MK16?
I speak under correction. When Mr. Sissoko is not there, for me to ask or request that he engage with somebody, it would depend who's acting in his place, and I need to check if Mr. Perumal was acting at the time, or we also have Chief Criminal Investigator Lusanda Boy, to whom we would allocate. It might be on that basis that he was therefore approached to deal with this matter, because we would need an investigator to be able to interview Mr. Adams.
So for Chief Perumal to have been the one, of Mr. Boy for that matter, whoever you have appointed, but for now you say you think it must have been Chief Perumal, for him to contact Mr. Adams following you receiving this letter, because at that point that's all you have,
Yes.
you would have had to say to him, I've received this letter, contact Mr. Adams.
That is correct, Chair.
Okay, thank you.
And thank you, Commissioners.
So at that stage, neither Mr. Sissoko or whoever else was involved. It was you, and you directly said to Mr. Perumal, contact Mr. Adams. No involvement of Mr. Sissoko.
No, because we haven't had the 27 yet.
All right. I'm asking to be sure, because earlier when the same question was asked, you mentioned Mr. Sissoko, you mentioned somebody else, and that just confused issues. So, all right, thank you, I understand.
Thank you, Chair. So then, just so we understand where we are at, you've now received MK16. You indicated that you did not refer to an investigation, because it did not have attachments. But we know from the letter itself that it had written correspondence addressed to the Minister of Police. What attachments did you consider were lacking that made it, the absence of which made it difficult for you to act on this letter?
I only have these 2 pages.
Ma'am?
I only got these 2 pages.
Let's go to that, the very letter. It reads in the first paragraph, attached here to please find for ease of reference a copy of written correspondence addressed to the Honorable Minister of Police, Honorable Senzo Mtunu by Member of Parliament, Honorable Fadil Adams.
Yes.
So you say you didn't have?
I only had these 2 pages that you have here, page 310 and 311.
Please say that again.
I only had these 2 pages.
Oh, the 310, 311 is the
310
page,
and
yeah.
311, yes.
So, did you go back to Mr. Nkabinde and say you forgot to attach the written correspondence between the Minister of Police and Mr. Adams, which you had kindly offered for ease of my reference? You didn't do that?
That is why I'm saying we need to look for the response to this letter, where I would have acknowledged the letter and in all likelihood would have asked for that which is short, attached, please find a reference. I would have asked for the written correspondence.
But definitely you recall you didn't have that correspondence
I
attached.
recall I didn't have that correspondence.
You then, as you testified, you instructed Chief Perumal to be in contact with Mr. Adams to obtain Section 27 affidavit.
That is correct.
Now, I want to suggest to you, so effectively, IDAC solicited a Section 27 affidavit from Mr. Adams.
I tell you now, when you look at the 27, we didn't take the 27. They would have contacted him, and I guess this is what we got. I speak under correction. Mr. Perumal would have to answer what he got from Mr. Adams, but what we got was a 27 dated the 21st of November, 2024.
That's fine. My question is, that document you're holding in your hand, IDAC solicited it from Mr. Adams. You received a letter from the minister. You then directed Mr. Perumal to act on that and contact Mr. Adams and
Ask him for his-
ask him. So you solicited a Section 27 affidavit from a would-be complainant.
I don't agree with the solicited.
Ma'am?
I don't agree with solicited. We would have asked him. Because, you see, I'm going into the detail that's not mine and not in my head, and I don't want to
It's
sound like I...
yours, it's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please
Understood.
do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Then we would have obtained the statement.
At your instance, that's the substance of the question.
That is correct.
That's what Ms. Sillo means when she says to you, so you solicited the affidavit, because what came out of your instruction that please contact Mr. Adams was the submission of the Section 27 affidavit. So it's on that basis that Ms. Sillo is suggesting to you, you solicited that affidavit. Do you now agree?
I agree.
As you sit here today, is that appropriate of IDAC to be soliciting complaints from members of the public on the basis of which then IDAC initiates investigations?
No, we're not supposed to solicit. And that is why I'm saying I tell Mr. Perumal to engage Mr. Adams. I don't know if this was a prepared affidavit already. It was to say to him, we received a letter from the minister. We are engaging you. So whether this was already prepared or not, at the time, we got this affidavit.
Okay, so then you recall when we're looking at MK16, the last sentence in MK16 before the signature by Mr. Ngabinde states, Honorable Fadiel Adams was advised by this office to await your decision in this regard. So it's fair then to conclude that your decision that you communicated to Mr. Adams is prepare an affidavit, Section 27 affidavit, and submit to IDAC. That's what you must have advised Mr. Adams based on your testimony.
That is what the advice would have been.
Okay.
Just on something you said in response to Ms. Sillo's previous question. You touched on the possibility that, not stating it as a fact, that the affidavit, you do not know whether the affidavit had already been prepared at the time of your instruction to Mr. Perumal. Did I understand you correctly?
That is correct, Chair.
No, that's not a fact. Look at that affidavit. It's dated 21 November 2024.
Yes.
And the minister's letter
Is
is the 11th of November 2024. So there was no prepared affidavit. I thought I should just put that out of the way. That's something you must accept, correct?
I hear what the Chair is saying.
Yes. All I'm
Yes.
saying is, let's forget about the possibility of an affidavit that could already have been in existence between the time that you got the letter from the minister and the time that this affidavit was eventually submitted to IDAC. That's not a possibility.
Correct, Chair.
We do see the correct facts here. Thank you.
So the upshot of all of this is that the referral to IDAC was by the minister's office. And following that referral, IDAC then made a decision to engage with Mr. Adams to obtain an affidavit from him.
It follows, Commissioner, yes.
And thank you, Commissioners. I suggest to you that you did that because you knew as ID that the minister's letter does not constitute a Section 27 referral. And IDAC decided to cure that deficiency. If we look at Section 27, it says the complaint must be on affidavit. So you knew that the minister's letter would not be sufficient to trigger your mandate. And you sought to cure that shortcoming. I'm trying to flight Section 27, if you have it close by. There, it's on the screen. You see Section 27 states, if any person has reasonable grounds to suspect that a specified offense has been or is being committed, or that an attempt has been or is being made to commit such an offense, she may report the matter in question to the head of the investigating directorate by means of an affidavit or affirmed declaration. You see that? And you're quite familiar with Section 27. You nod. Please articulate
yes,
your
sorry.
response. Thanks.
Yeah.
So because you read the minister's letter and you saw the difficulty that it would not trigger your power to investigate, you contact Mr. Adams through Mr. Perumal to cure that problem and to provide a Section 27 affidavit.
Yes, as the minister refers, referral and request for investigation in terms of Section 27, but there isn't a Section 27 there. And so by virtue of what you're saying, we had to go ahead then and get a Section 27.
Why?
Because there is no 27 that is referred to us through that letter.
Please go to MK 15 and look at the correspondence that I understand that you received attached to the letter by Mr. Ngabinde. And MK 15, I would like to refer you to page 28. Let's start at 282, but then in particular, I would like us to have regard to 283 and 284. From our records, we are aware of a letter to, an email to the minister at the bottom, starting at the bottom of page 283 of MK15. And from Mr. Adams, if you look over leaflet 284, and in that email, having stated what his issues are at 5, he states, I urgently and humbly ask for the minister to intervene and ensure the integrity of investigative process is maintained to ensure a fair and just outcome. You see that? Do you see where I'm reading?
Yes.
And then if we go back to 283, then we see communication from Mr. Ngabinde to Major General Sebola, referring this complaint and requesting that a report be filed with the minister or the minister's office by Monday, the 4th of November. Now, if the email at page 283 at the bottom from Mr. Adams reflects a complaint as reflected in sub 2 at the bottom of the page. He said to Minister of Police 1, I have opened cases, you see that?
Correct.
And if we go to 2, he says, I was told that the dockets were intercepted. And then in his quest for justice, he says he would travel to Gauteng to open dockets. However, I've also been notified that the Gauteng Police Department has followed the same modus operandi as the Western Cape and is interfering in the investigative process. I urgently and humbly ask for the minister to intervene and ensure the integrity of the investigative process is maintained to ensure a fair and just outcome. So, my understanding of this email is what Mr. Adams wanted was that the investigative process of the cases, the dockets he had opened, the integrity of that process be maintained.
Correct.
You understand, you have the same understanding as well. Now, assuming for a moment that this is the communication that was attached to MK16, the letter addressed to you, what in this would trigger your mandate? Remember, in your affidavit, you set out your section 7A of the NPA Act. You do so at paragraph 8, page 3 of your first statement. And you do quote the Act that your mandate is to investigate serious, high-profile or complex corruption, commercial and financial cases that sub-A, sub-B relating to additional related offenses or categories of offenses, including, and then it lists, and then at C, relating to additional related statutory offenses or categories, including contravention of specified acts. If we take MK16 and we take this communication that I suggest was attached to that letter, what in these documents triggers your mandate in terms of section 7A? Do these documents reflect a serious, a high profile or complex corruption, or a serious, high profile or complex, however that is read? What about the contents of those documents bring this within the mandate of IDAC to justify your initiative to direct Mr. Perumal to go obtain a Section 27 affidavit?
If this was in fact the document that was attached, it doesn't trigger.
And if that document wasn't attached, it's even worse, because the MK16 itself gets nowhere close to Section 7A on its own without this communication.
There's the two possibilities. If
Yes.
this was attached, the only time that it would have triggered anything however, I have been notified that the heart has followed the same as interfering in the investigative process. That might have triggered looking at whether or not there was defeating, but I can honestly tell you I can't recall this document, so it cannot have triggered IDAC's mandate.
Are you referring to the emails now? When you say this document, are you
sorry,
referring to MK15, the emails?
The 283 and 284.
Pages
MK
283,
page-
284.
Yes.
That's the emails.
The emails, yes.
You are referring to a document singular, but Ms. Silo's question, as I understood it, was referring to both the emails and MK16, which is the letter from the minister. So don't leave that out. What about that letter? From that letter, do you see anything that triggers IDAC's mandate?
Sorry, let me just go back here, Chair. I don't have it straight off my head. Chair, if that was attached, and when you look at paragraph 2,
Starting with what
the
words?
allegations
Yes.
contained therein implicate very senior members of the South African Police Service and are viewed in a serious light, and case dockets were registered as, and due to the nature of the allegations made by the Honorable Adams, which is deemed to be quite sensitive and which contains allegations of criminal conduct, the office requests the investigating director to consider investigating the same.
That says nothing. That says nothing altogether. We do not even know what those allegations are, whether serious or not. That basically says nothing. And if I were to refer you to one of your own statements, I think that's your second statement where you were required to respond to issues about the docket which you are alleged to have shared with General Khan. You had, in respect of that issue, the ability to say this is vague. It doesn't say when, it doesn't say by whom, it doesn't say, and you went on and on to demonstrate that it was vague. That same thought process by you ought to have applied here as well. There are so many whys, how, by whom, when, about what exactly. There are so many of those. If you are able to apply that thought of process or that kind of reasoning, why did you not apply it here? It's on that basis that I say this says nothing at all. So by parity of reasoning, in accordance with your own reasoning, when you concluded that what you were being asked was vague, why did you not see this as vague as well? It says nothing, I suggest to you. Do you agree or not?
It may say nothing in there, it refers to the dockets.
So you are happy that it says nothing.
It doesn't make out any allegations.
Exactly, exactly. Now, go to section 32 of the NPA Act. And please tell me when you are there. 32.
I am the chair.
Do you see that in subsection 1, that is section 32(1), there it's stated how you are to carry out your functions, and that is amongst others without fear, favor, or prejudice. And what I want to emphasize here is without fear. And then in subsection 2, that is section 32(2), the oath of prosecutors is actually set out there. You do see it, eh?
I see that, Chair.
It also captures the same words, without fear, that is, you will exercise your functions as a prosecutor, and you happen to be a senior one at that. So you will exercise your functions as a prosecutor without fear, favor, or prejudice. Again, I emphasize without fear. Now, if you accept, as you have just done, that there was nothing whatsoever in the minister's letter, what stopped you from writing back to the ministry and saying, we do not have a section 27 referral, therefore, we cannot do anything about this. And you did not even have to go to the content of the letter. But because there was nothing in the content of the letter that should also have given you comfort as a prosecutor that I do not have to follow up on anything here because there's nothing. You have accepted that there was nothing. Why did you not write back to the minister and say, in the absence of a section 27 referral, we as IDAC cannot do anything? So that it would then have been the ministry that saw to it that a section 27 referral was placed before IDAC. Why did you not write such a letter? Were you fearful of the minister?
Not at all, and that is.
Why then did you not write such a
That is why I
letter?
said, Chair,
Sorry, you
Sorry.
spoke over me. Why then did you not write such a letter?
that is why I said, Chair, we'd have to look for the letter that the response. What did I write in my response to the minister?
But
I
surely,
don't think that I got
surely,
a response.
sorry. But surely, that letter could not possibly have said, Minister, we are not going to do anything about this because there's no Section 27 referral, because that would have been at variance with or at odds with you instructing Mr. Perumal to follow up with Mr. Adams. So that letter, even if we were to look at it, it's not likely to have said what I'm suggesting you ought to have done. So do you think that letter is going to assist you?
I'd have to look at the contents.
Do
of
you
the
think it's going to assist you as you sit there, seriously? Do you think it's going to assist you?
Not at all.
It cannot possibly do so. It cannot possibly do so because such contents would have been, as I say, at odds with the instruction you gave to Mr. Perumal. You agree?
I agree, Chair.
Thank you.
Yes, ma'am. Can I just follow up on that? And I want to make a proposition to you that when you look at the letter from Mr. Nkabinde, as you agree, it says nothing. It says, I attach a copy of written correspondence from Mr. Adams to the minister, not to you. And then it gives a list of cases. It says allegations contained therein implicate very senior members of the SAPS and are viewed in a serious light. And case dockets were registered, and he gives you those case dockets. And then he says, due to the nature of the allegations made by Fadil Adams, Honorable Fadil Adams, which is deemed to be quite sensitive and which contains allegations of criminal misconduct, this office requests the investigating director to consider investigating the same. And then the last is, you will advise him what you're doing. You'll advise Mr. Adams. Now, for you, the proposition that I want to make to you is for you to instruct Chief Perumal to speak to Mr. Adams. You must have had sight of these emails for you to form a view that there is possibly a matter that falls within our Section 27. You must have looked at MK 15-282. Otherwise, your decision doesn't make sense. That just on MK 16, you say to Mr. Perumal, speak to Mr. Adams. When 16 says nothing, as the chair says, it doesn't allege what crime it speaks about. Allegations are sensitive, doesn't tell you anything. So you don't know whether they're talking about theft of a notebook on MK 16. Could have been anything. So it cannot be. And I would be surprised if you acted on MK 16 to say to Mr. Perumal, speak to Mr. Adams, so that we can get an affidavit from him. That conduct of yours to say to Mr. Perumal, to Chief Perumal, speak to Mr. Adams, makes sense only if you've seen these emails and you've seen that there are allegations of interception of dockets. As you were starting to say that the email seems to speak to corruption of sorts, you have to have seen this. That's my proposition to you, that you must have seen these emails by the time or before you spoke to Perumal, and that's what informed you saying to Mr. Perumal, speak to Mr. Adams. What do you say to that?
I can't disagree with you, Commissioner Baloyi.
Thank you.
Sorry, let me just follow up on a response you gave when I engaged you. So in the end, you accepted that you could not possibly have written a letter to the minister saying there's nothing we can do in the absence of a Section 27 referral. So you accepted your letter could not possibly have said that. I asked you, did you act in the manner in which you did because you were fearful of the minister? And I thought your response was in the negative, correct?
Correct.
If you were not fearful of the minister, why then did you act? What motivated you to act in circumstances where there was nothing in the content of the letter from the minister? You were not fearful of the minister, as you suggest, but you still went ahead regardless and gave the instruction that you gave to Mr. Perumal. What motivated you? What was the motive behind your action? If it was not fear of the minister, what then was the motive for you to act in the manner in which you did?
Is to follow up on, is there a Section 27?
Is that all you asked Mr. Perumal to do?
That is all, because there's a reference to a Section 27. There is no Section 27. Mr. Perumal to contact Mr. Adams to find out if there's a 27 or to get a 27.
Did you say this before, or are you saying it for the first time? If you did say it, I may have not heard you. What I'm referring to as to whether you are mentioning it for the first time now is whether your instruction to Mr. Perumal was for him to find out if there was a Section 27 referral. Did you say that before?
No, Chair, I didn't say that before.
You are saying it for the first time now. I would have expected you to say that much earlier, but I will leave it at that.
I'm reading again.
Sorry?
Sorry, I was reading again and going through what it asked.
Okay, thank you.
Thank you, Chair.
Advocate
If
Johnson, sorry, one last one. Do you see that as far as the minister is concerned, his letter was the Section 27 referral? Because if you look at the heading, they say referral and request for investigation in terms of Section 27. So as far as the minister was concerned, this is the Section 27. So the appropriate answer from you would have been, this does not comply with Section 27. That's the end of the story.
In fact, to add to that, nothing in this letter leads you to Mr. Adams. As Commissioner Khumalo says, it is the ministry that is referring and purporting to refer in terms of Section 27. And if you were going to ask for a Section 27 affidavit, it is from Mr. Nkabinde that you ask for, because he's the one that's purporting to refer. It doesn't direct you to Mr. Adams. The complaint has been laid with them, and Nkabinde says, I'm lodging a Section 27 complaint. And you have no business, at least on the basis of this letter, to go to Mr. Adams for a Section 27 affidavit. You go to Mr. Nkabinde for a Section 27 affidavit. You say to him, this is not a proper referral. If you want us to investigate in terms of Section 27, as Commissioner Khumalo says, give us an affidavit.
I read it differently, Commissioner Balo.
How do you read it differently?
It says referral and request for investigation in terms of Section 27. And he does make reference to the Honorable Fadil Adams. We don't have anything from Fadil Adams. And so the request to Perumal to get a Section 27 from Fadil Adams is based on the referral and request for investigation in terms of Section 27.
Mr. Nkabinde is asking you to investigate. Mr. Adams is not asking you to investigate. He has not communicated with you. He hasn't. Even on the version which you, on the proposition that I made to you that you must have seen the emails that he sent to the minister, even on that, he's not directing anything to you. It is Mr. Nkabinde. He raises his complaint with the minister. That's what he does.
Yes.
The minister's chief of staff lodges with you a complaint, and he calls it a Section 27 complaint. The only reference he makes to Mr. Adams is to say, we've received the minister has received a complaint from Mr. Adams. Please investigate. And I refer this to you in terms of section 27. So the person that must give you the affidavit is Mr. Nkabinde, and it's not apparent why you thought that this is a complaint to IDAC from Mr. Adams, because it's not a complaint from Mr. Adams to IDAC. At this point, it's not.
I see where you're going to, Commissioner Bala.
It's like this,
But
Advocate.
no, sorry. Do you agree? Do you agree?
I agree with her interpretation, yes.
Thank you.
It's like this. So Mr. Adams writes to the minister's office. He's unhappy about the 4 dockets, and he asks the minister's office to intervene. So the minister's office has at least 3 choices. One is the inspectorate, the other one is IPID, and the other one is IDAC. So they have those 3. So far you are with me, you agree?
I agree.
Based on the nature of the allegations, as vague as they are, they have those 3 options. The minister's office then picks one, and they say, we pick IDAC. And we will do a referral to IDAC in terms of section 27 of the NPA Act. It's not Mr. Adams who says, I choose IDAC. It is the minister's office, based on what we see in this letter. Do you agree so far?
I agree so far.
Yes. And they say, as far as the minister's office is concerned, the allegations in the correspondence by Mr. Adams, they regard them as quite sensitive. That's the minister's office. And they contain allegations of criminal misconduct. That's the minister's office. They then say, this office, that is the minister's office, this office requests Advocate Johnson to consider investigating the matter. That's the last paragraph on 310. So do you see that it refers to this office being the minister's office? Do you see that?
I see that.
And it is the minister's office that is asking IDAC to investigate.
Correct.
Yes. So the request is by the minister's office. And they say Adams was advised to await Advocate Johnson's decision. A decision on the request by the minister's office.
Yes.
Do you accept that? Yes.
Thank you, Commissioners. If I could just add, and what the minister's office requested IDAC to investigate is the alleged interception of the dockets. That's it. Not the allegations set out in the respective dockets. That was never the request to you. Do you accept that?
I accept that.
So if you understood the request to be an investigation into the alleged interception and interference of dockets opened by Mr. Adams, that surely should have been the confines of your investigation. Whether or not dockets were opened and intercepted, whether there has been interference with the dockets, regardless of the content of the dockets. Because otherwise, you would have been investigating what you were not requested to investigate. Would you accept that your investigation would have been that narrow, would be looking into the interception only?
In terms of this letter, yes.
Yes. So we then, if we look at the emails at 283 and 284, that is consistent with what Mr. Adams complains about in his emails to the minister. It is the interception. After tea, perhaps you will shed light on having solicited the Section 27 affidavit as IDAC did. How do we end up with claims of Khumalo, Lushaba, Madondo, siphoning money from the secret account fund with cover-ups of General Lushaba's incident with the appointment of a lady working at BMW in a sensitive post how does that fit into the request, specific request made to you of interception? Why is Mr. Adams's affidavit not confined specifically to the complaint he had laid with the minister? Was that at the instigation by IDAC? It can only be at the instigation of IDAC. So there's Mr. Adams' complaint of interference, and then there seemingly is a parallel investigation attached to that complaint initiated by IDAC. Is that where we are at?
I'm going to come back to you after tea because I'd have to speak to Mr. Perumal about what he spoke to Mr. Adams about and how we arrived at this.
No. You will come back.
At that point, perhaps let's take the adjournment
Okay.
and come back at 11:35.
Thank you,
Let's
Chair.
adjourn.
It's 11:34. We are ready to resume. Please make sure that your devices are quiet. Thank you.
Yes, Ms. Sillo.
Thank you, Chair. Advocate Johnson, when we broke for tea, we had established that the minister's office complaint was based in turn on Mr. Adams's complaint of interception of his dockets. We agree that.
Correct?
Okay. We know that upon receipt of that communication from the minister's office, with or without annexures, you then instructed Mr. Perumal to obtain a Section 27 affidavit from Mr. Adams. My question was, if the complaint was interception of the dockets, not the content of the dockets, by you I mean IDAC, must have instructed Mr. Adams to include in his Section 27 matters that do not constitute interception. And you indicated that you needed to talk to Mr. Perumal. I take it you've had a chance to and are able to shed light on how we end up with a Section 27 affidavit reading as it does, inconsistent with the complaint laid before IDAC by the minister's office.
Commissioners, I did call Mr. Perumal during the tea break, and I give feedback as follows. The referral and request for investigation in terms of Section 27 in the letter by the minister referred to Honorable Fadil Adams and referred to dockets. The ID asked Mr. Perumal to contact Mr. Adams to find out if he had a 27, which he did. He called Mr. Adams to indicate that IDAC cannot assist you in the absence of a Section 27 referral. Mr. Adams said, I have dockets opened already that make out allegations. Mr. Perumal advised him that we cannot just take those dockets in the absence of a Section 27. He told him to see a legal person and look at Section 27, and if he was of a mind to then refer a matter in terms of Section 27. Accordingly, there is a 27 dated the 21st of November, signed in the Western Cape, that was compiled by Mr. Adams without IDAC, which he sent and which has the detail it has.
The complaint, the only complainant as at the 11th of November was the Office of the Minister. And that complaint concerned interception of dockets. So the complaint itself does not concern itself with the contents of the dockets. It's only the act of interception. Do you agree with me? That is what was communicated to you by the Minister's office on the 11th of November in terms of Annexure MK16.
I beg to differ, if I could explain.
Yes, please.
The Minister is not just referring to the dockets. The Minister says, the allegations contained therein implicate very senior members of the South African Police Service and viewed in a serious light, and case dockets were registered as per the following cases, meaning whatever allegations that implicate senior members of SAPS are in these 4 dockets referred on 310. He goes further to say, due to the nature of the allegations made by Honorable Fadil Adams, which is deemed to be quite sensitive and which contains allegations of criminal misconduct, this office requests the investigating director to consider the same.
Okay, now let's look at the paragraph you just read, the allegations contained therein. What the reference to the therein, and I propose to you that therein is the correspondence addressed to the minister. So the allegations contained in the correspondence from Mr. Adams to the minister implicate very senior members of the South African police. And the implication is that they intercepted the dockets.
I don't read it like that.
How do you read it?
I read that the allegations contained therein, in these dockets, in the dockets, implicate very senior members of the South African Police Services.
What in this communication gives you a sense that the minister or Mr. Nkabinde has seen the contents of the dockets?
I'm not saying they saw the contents of the dockets. They refer to Mr. Adams, and they say the allegations contained by Mr. Adams implicate very senior members of the South African Police Service and are viewed in a serious light, and case dockets were registered as per the following case numbers.
But if your reading of this letter is correct, then the minister's office must have seen the dockets. Otherwise, they're not in a position to express a view that the allegations are viewed in a serious light and that they are quite sensitive, what is contained therein. If it is a reference to the dockets, the minister must have seen these dockets for your reading to be correct. It must be so.
For the way I read them, Commissioner Baloy, he refers to Adams. Adams would have made the allegations. I'm not sure in what form he made them to the minister.
No. What we know from this letter is the minister has been given correspondence by Adams. That's what that letter says. There's correspondence from Mr. Adams. You say the second paragraph and the third paragraph do not refer to that correspondence unless you're suggesting the minister must have had a telephone call with Mr. Adams, and that's why he's able to talk about these dockets, the content of these dockets. And I suspect that's not what you want to say. Because the next question would be, how do you know they had a conversation about the dockets and what's contained in the dockets? So let's read the letter sensibly. Paragraph 1 says, I attach a copy of the correspondence received from Mr. Adams. That's what it says.
Yes.
And then paragraph 2 says, the allegations contained therein implicate serious members of the South African police. I want to say to you that a sensible reading of this first paragraph and the second paragraph is the contained therein refers or must refer to the attached correspondence. That is a sensible reading. Otherwise, why does he mention that letter to you?
That is correct.
Yes. So your reading of it to say, well, when he talks about implicating senior officers and containing sensitive matter, he's referring to what is contained in the dockets. It doesn't work. It's not a sensible way of reading this letter. But more importantly and seriously, it works only if you say that the minister must have had a conversation with Mr. Adams about these dockets to know that matter contained therein in those dockets is sensitive and it implicates senior police officers. And who are those senior police officers? You agree with me? You must agree with me.
I agree with the reading of a copy of a written correspondence which would have set out those serious allegations as contained.
Yes.
And therefore the reference to the dockets because he refers to the dockets.
Yes.
But that the written correspondence would have set out these serious allegations.
Yes, that's the only way it works. Thank you.
And for that, you would have to go to page 283 of the same bundle. 283.
That is the correspondence we suggested was attached to the minister's
The serious
letter.
allegations implicating senior officers are contained there because
Apologies, Commissioner. MK 15, Please go to MK 15
I am there.
and then to page 283.
I am there.
Thank you.
So that email of 1 November 2024 at 8:21, that is the correspondence addressed to the minister. And the docket numbers are there. And then allegation 2 is that I was told the dockets were intercepted. And then he says, I traveled to Johannesburg, Orlando, opened new dockets you see there. Then he implicates senior officers because he then says they interfered in the investigative process. And he was notified that Gauteng is following the same process. And the request to the minister is, I urgently and humbly ask the minister to intervene to ensure the integrity of the investigative process is maintained. So this is the request that gives rise to the referral to IDAC. And that was Advocate Sillo's point, that the referral to IDAC was about these allegations implicating senior officers, not for IDAC to go take over the dockets that were opened in Orlando and the Western Cape and investigate those underlying allegations in those dockets. So having seen this, you can now go back to the letter and then respond. Sorry, having seen this, you can now go back to the letter. It's on 310 and respond to Advocate Sillo's question.
I still maintain that although you have that email, this letter tells you referral and request for investigation in terms of Section 27. It does talk to copy of written correspondence to the minister by Fadil Adams, and therein are serious allegations. And due to the nature of these allegations, they are referring then to the allegations as he makes out in his written correspondence, which must almost invariably, it would seem, refer to the dockets. That is my reading, Commissioner. I'm not saying that it cannot be read differently. I'm saying that is my reading. And I can't take it further than that is my reading of the title, what is referred to, and what subsequently happened.
And you insist on that reading, notwithstanding the fact that it belies any logical form of interpretation, but you insist on that wording, on that interpretation.
I believe that the interpretation is logical.
Okay. Now, under which case number or inquiry number did IDAC investigate the claim of interception? That's the original claim by Mr. Adams. That is the complaint that the minister purported to refer to IDAC.
So in the communications with Mr. Adams, he was asked for his Section 27.
I'm asking under which case number or inquiry number?
It
there.
would all have been under the one inquiry under which the Section 27 came. There wasn't a separate inquiry for an interception or a separate inquiry for something else. When the 27 came in, if I may, Counsel, when the 27 came in, it was given a reference number.
Yes.
And all those matters that flow from whatever the allegations are, including in the 27, where he says in one of the paragraphs that the dockets were intercepted or the dockets were taken for reasons that are not explained. They form part of his complaint.
Yes.
All one complaint.
Yes. I'm interested in the investigation into the interception because I did not see it in the docket, what we call the Mukwele matter. I didn't see that particular investigation in the docket, and I wanted to find out whether IDAC ever pursued that complaint, that specific complaint of interception of Mr. Adams's dockets. or whether it concentrated more on that part of the Section 27 referral that, as I suggest, was initiated by IDAC.
When the referral had come in, we had to find out where these dockets are. That was part of that exercise. In order to locate the dockets, to determine whether these dockets had in fact been intercepted and were no longer where they were. To that end, Council, what we did is we wrote, because his last reference is, I opened dockets in Gauteng. A letter was written to the Provincial Commissioner Detectives, Major General Khumalo, requesting the dockets.
I'm sorry to interject. Do you possibly have a date for that letter immediately at hand?
Will you please give me a moment? It should have been in that would have been the 6th of December.
Okay.
I speak under correction, but in all likelihood, it is the 6th. Sorry, I made a small note, 6th of December.
And did you receive a response while we are on that point? Did you receive a response, and if so, when?
General Khumalo, and sorry, this is a different
Yes.
Khumalo, not General Dumisani Khumalo. The PC for detectives indicated that he knew about these dockets, but that these dockets were not with him. He was going to tell us where to find those dockets. In the interim, he then indicated that the dockets could be with the DPCI. When we contacted the DPCI, these dockets were not with them. And in that process, one of the investigators found out that the dockets actually were with the SAPS inspectorate, more so the head of the inspectorate, General Peter Jacobs.
And when was this discovery?
All on the 6th.
All on the 6th?
All on the 6th, because we're looking for the dockets. He's saying the dockets are missing.
Do you know how he discovered that, by any chance?
I know that the investigator indicated that he received information. I don't have the detail of the information, but he received information that the docket is with the head of the inspectorate, Lieutenant General Peter Jacobs.
Going back to your team, we had quite a number of investigators there that you identified. Which particular investigator
It would
is
have
this?
been Mr. Rapesu.
Okay. We got a bit sidetracked. Remember, going back to the letter from the ministry regarding interception, I wanted to find out that the case of interception of the specific dockets listed there, where did that investigation end?
The dockets were found on that day.
Yes, should that not have been the end of your inquiry then?
No.
I mean, his complaint, remember his complaint is that dockets have been intercepted. That's what his emails are about.
Yes.
He's not making the allegations that you later find in the Section 27 that you have accepted, you solicited. So we're still at the earlier stages where you get a complaint that dockets have been intercepted. You are telling us that you then inquired and in fact found that they are accounted for in the SAPS system.
Yes.
You get told that. Isn't that the end of his complaint? And shouldn't that have been the end of the complaint?
Commissioner Khumalo, that was one part of
I'm still Commissioner Baloyi.
Sorry. He looks and smiles there the entire time. And so one invariably, I do apologize, looks at him. Please don't frown, sir.
I have to change because clearly that's a problem.
It is the one thing that gives comfort when you sit here as a witness is a smiling face. And we digress, and I apologize. It couldn't stop there, because we now need to see what's in these dockets, because here's an allegation that Adams is saying there are serious allegations I am making. They are contained in these dockets, but beyond the dockets, I have an issue because these dockets are missing. He does say so in the 27. So once we determine, Council, that the dockets are with the inspectorate, we cannot ask the inspectorate for the dockets. And I'll tell you why I say that. It's out of just normal practice.
No, just hold on your explanation.
Sorry, Commissioner Baloyi.
My question is pre the 27. We are still, the 27th is in November. Okay, now carry on. I do apologize.
Sorry, we get the section 27 on the 21st of November. That allows us to be able to look for what the allegations allude to. In order for us to have access to the dockets, police will not give IDAC dockets if IDAC does not have an investigation. On the 6th of December, we, having had the Section 27 since the 21st of November, the prosecutor, Advocate Ramsamy, is able to submit a Section 2813 application, which initiates an investigation. It is on that basis, Commissioners, that we are able to write now to the head of detectives, because ordinarily the custodians of the dockets, especially under investigation, are the detectives. We write to the head of detectives indicating that IDAC has initiated an investigation, and the investigation requires that we have access to these dockets.
Perhaps this might be the appropriate point to turn to the referral affidavit itself. But I do so momentarily for purposes of the complaint of interception. That would be at your file 2, page 512. That will run till 516. If we just run ahead to page 516, you confirm that is it's signed above the name F. Adams. Okay, Adams is misspelled, but I take it to be F. Adams MP, dated the 21st of November 24 in Cape Town, and commissioned by Commissioner of Oaths, as indicated. You confirm that?
I confirm, I
Now,
see that.
the conversation we're having, if we go back to paragraph 1, paragraph 1 reads as follows. In my capacity as a member of Parliament for the Republic of South Africa, I first opened 3 cases in Cape Town Police Station with case numbers Cape Town, and they are stated. After I opened these cases, I take it I was informed that the cases were taken from the Cape Town Police Station to the Office of the Provincial Commissioner, Western Cape. I do not trust the Provincial Commissioner General particularly, and believe that a deliberate attempt is taking place to get rid of the cases I had reported and to protect those against whom I made the cases. End of quote. That is the investigation I'm asking about. Did you ever investigate the claims against General particular? That is the interception. And I still don't understand whether or not you investigated that, you being IDAC, or you didn't. And if you investigated where you ever landed.
In all honesty, Council, I cannot tell you that there was a separate investigation about that interception.
Yes.
I know that we sought to find those dockets, and we then, in fact, found those dockets.
Your finding of the dockets surely doesn't address the complaint of interception?
No, it doesn't.
Yes.
And what I'm saying is there must be an investigation. I can come back to you with a reference to an investigation. But I know that at the time, the purpose was to first find these dockets, which we in fact did, and to then determine what the allegations are in those dockets. Do they talk to the 27, and what is the way forward?
Okay, so would there be an investigation in your office that you don't know about? Because your answer suggests that your people may well be conducting investigations that you're not aware of.
Not that I won't know of an investigation, but when you have matters of this nature, Commissioner Baloy, they divide the matters up into different legs of investigation so that they can deal with them differently. I may not be aware of a specific leg of investigation, but I am aware that there is an investigation or investigations arising out of the Section 27.
So you would expect?
I would expect.
And we should expect that when you come back to us after lunch, you will tell us there is an investigation into this interception. This is the team that is dealing with that, and it is being done under case number so-and-so. It's information that you should be able to get. Thank you.
Thank you, Commissioner Baloy. So then just to recap where we are at, we know that we started with email communication by Mr. Adams to the Office of the Minister. The Minister then directed the letter, dated the Minister's office, directed the letter dated the 11th of November 2024 to yourself. And we know that subsequent to that, you directed Mr. Perumal to obtain an affidavit from Mr. Adams. We are in agreement there. Okay, where did I lose you?
Sorry, correction on the last part. Or let's leave it at that. I think it's semantics. It's okay. I'm not going to fight about the semantics. Sorry, Chair.
Then having done so, and the issue at the time was interception of the dockets. A claim by Mr. Adams. It was the interception of the dockets. What we don't have before us is a file on the investigation regarding that particular complaint. What we then have instead is what we have come to call the Mukwele matter, which then is born of claims advanced by Mr. Adams at the instance of IDAC, as reflected in the Section 27 affidavit. Do you agree with me thus far?
Yes, and that we miss a matter before the Mukwele matter, which was the Lushaba matter. That was the first matter that was dealt with. And then it was the Mukwele matter.
Okay.
I just didn't want us to miss that.
I'm not sure I understand, because in this complaint, we are going to come across the Lushaba matter.
Yes, and
now, is that a separate investigation?
that was dealt with. So what the prosecutors did.
Let me just say something to I guess, clear the cobwebs in my head. I want to determine how many separate investigations there are. My first was that the first investigation would at least have involved an investigation into the conduct of General Petekile as set out in paragraph 1. That you say you'll check on the file regarding that investigation. The second is the Mukwele matter, quote, quote unquote. It's unfortunate we have to use a name in that manner, but it's the quickest way of making reference without confusing each other. Now you're suggesting that there is a third investigation on the Lushaba matter.
When the prosecutors got the Section 27 referral counsel, they broke it up as follows. Started with the General Lushaba matter.
Yes.
That's the first matter. The Mukwele matter being...
Apologies, just a second, thanks. Thanks, you may continue.
Thank you, Commissioners. So when the matters were broken up, and I think they were broken up, as the prosecutor explained, in terms of the different categories of offenses if you took them all as one, we would have had a lot of issues from misjoinder to 10 people standing in the dock, one facing one count of something and someone facing 10 of the other, and it would have been a mismatch. So they took it in terms of the allegations and grouped them accordingly. In terms of what happened in the sequence would have been, as they identified, the housebreaking incident of General Lushaba. That was the first investigation, that was the first matter, counsel, that was enrolled. Thereafter, it was the Mokwele matter. There is then a third investigation, that is the one for which the warrants were held over, just for context, in terms of Lieutenant General Khumalo and General Madondo. And then there are other matters that also emanate from this complaint.
How many other matters?
There are, I know for 4, 5, there would be 6.
6 other matters.
6 other matters.
And they all, you say they all emanate from the Section 27.
That is correct.
Are you able, over the course of the lunch break, I guess, to prepare a list for us of those matters and to indicate whether they are filed, they have different case numbers or inquiry numbers or any other useful reference?
I do know that with the Lushaba matter, it's a separate case.
Yes.
Of course, as is with the Mokwele matter.
Yes.
And that had the other matter been enrolled, it would have also had its own case.
Yes.
Okay.
And that's why I say it might possibly be a case number or an inquiry number, just so we know which we are pursuing. Now that we have started with the Section 27 referral, let's for a moment go back to Section 27 of the NPA Act.
Before you do that, can I just check that the attorneys have given you a copy? Because I saw that you were struggling. Can they just make sure that they give you the copy of the act?
Apologies, I'd assume the witness perhaps was...
I do. I'll keep this one here. I think I do
she's
have
got her
one,
own version.
and, out of habit,
I noticed that when Chair was engaging you, you were struggling finding...
I think it's because I had too many documents on my table, Commissioner Khumalo.
So we took the extra effort to ask the attorneys to make a copy and put it in a
Thank
file.
you very much.
Thank you,
And then
Commissioner.
I'm going to be respectful and use the file that was made available. Thank you.
I think so, Advocate Johnson, after all that effort,
Effort,
right?
yes. And the few trees that we might have.
Absolutely.
Yes.
Absolutely. We are now at Section 27. And Section 27 tells us the affidavit, what the affidavit contemplated therein must contain. Correct? I'm sure it's a section you are well familiar with. You've had a number of
Yes,
referrals.
I just went to the wrong side. Sorry. I am there. Thank you.
Section 27. So you do agree, sections 27 sub A, sub B, and to some extent sub C, if there should be other relevant information, dictates what the affidavit should contain, Section 27 affidavit.
Correct?
What are the consequences where an affidavit lacking in complete compliance with Section 27, what would be the consequences insofar as IDAC's trigger is concerned?
Where an Section 27 affidavit is insufficient for any one of a number of reasons. We ordinarily would ask the complainant to supplement or amplify and indicate what the shortcomings are, which parts are short. If the complainant is unable to amplify any one portion or portions that would then fulfill the requirements of Section 27, we then have to indicate that we are unable to take the matter because the matter must fulfill certain requirements.
Okay. Thank you. Let's turn then to the Section 27 affidavit that we received.
Do you do this, that is the a request for a supplement? Do you do that in all instances where an affidavit is lacking in the necessary detail?
Chair, especially where just from a glance, it would seem that they're just missing something and there's a likelihood it falls within the mandate. You ask them, and when they amplify and you say, okay, it still falls short.
Okay,
then
so
we don't.
that's exactly what I wanted to find out. So reading it, you are of the view that it does fall within your mandate, but you just want a supplement on certain specific issues or on a specific issue. But at least it's already there within the realm, as it were.
Correct, Chair.
Meaning, if it's woefully hopeless, you just reject that, correct?
That is correct.
All right, thank you.
Just follow up on that by way of an example or question. So we're looking at 27 and the requirements thereof. If you're given an affidavit that says, I suspect that money is being stolen, that's A. So they've told you the nature of the suspicion. And then they don't tell you the grounds on which the suspicion is based. And whatever else they say in C does not tell you the grounds on which the suspicion is based. There's been a non-compliance with B, right? What do you do?
You would then check if they have a source of information. That
So
is,
you would
what
still
do you
ask
base
them?
it on?
Sorry. So you would, even if they haven't set out grounds in their affidavit, they simply say, I suspect money is being stolen. You're saying you then ask them for a supplementary affidavit?
No, if it's just, I suspect, and there's nothing more to it, then it does not fulfill.
And so,
Because, sorry, Commissioner.
yeah, no, Kira,
You have to be mindful of the prodding.
yes.
And trying to elicit something they know they should tell you. Because what does happen is, ordinarily, without saying what you want, we are able to engage a Section 27 referral and indicate these are the requirements. Your affidavit does not make out these requirements. And there and then, in almost most cases, people are able to say, well, I gave you what I have. And that just finishes that part of it.
Thank you.
And when people tell you, I gave you what I have, and there are clearly no grounds in that affidavit, what does IDAC do?
It may be, Council, that it is insufficient for the purposes of IDAC. Where it has been insufficient for the purposes of IDAC, but we are aware that it could go to the detectives and or it could go to the DPCI, we write to the referral or to the referee, I apologize, to indicate whilst this does not comply with IDAC's mandate, you are able to refer this matter to the detectives. We are writing to, so we do two things. We inform the complainant where they can go to, and then we also write to the agency that we are able to send it to, together with a copy of whatever information might have been received. We have also been able to do that where, for example, it is something that is civil in nature, but falls within the mandate of the SIU. And we would say to them, you might be able to find recourse here with the SIU. So we don't just leave them in the lurch if, in fact, it does make out allegations that are investigated by a different agency. We write to them, we write to the agency, and we send that material as well.
So at least where we land, and I'm testing my understanding of Section 27, there are two main requirements in that section. The affidavit must spell out the suspicion that the referee holds, and then to advance grounds to support every specific suspicion. IDAC has got the power to request maybe substantiation, clarification from the referee, where there are shortcomings with compliance with Section 27. In the event that the suspicions are not substantiated and grounds not advanced by way of example, then IDAC cannot investigate the matter. It would normally refer it to another appropriate law enforcement agency.
Correct,
Is that a fair summary? Let's look then at the Section 27 referral received from Mr. Adams. We will work through it in detail, but my summary of it I would like to share with you. What that affidavit, and that's file 2, page 512.
I do have it.
Thank you. That affidavit states the following. It highlights or shares with the reader 3 key suspicions that Mr. Adams harbors. The first is at paragraph 2. And therein, paragraph 2, it says, it expresses his growing concern that the head of crime intelligence, General Khumalo, General Lushaba, General Madondo, and other senior crime intelligence officers are busy with systematic capture of crime intelligence division. That's his first suspicion.
Counsel, may I ask a question? Am I allowed
Yes,
to
ma'am,
make
of
marks?
course.
Am I allowed to write
Yes,
on this document?
yes.
Okay, thank you.
If it's in the witness file, we will just replace it with a fresh copy.
You
So-
said, sorry, Counsel, you said that is the first allegation.
Yeah,
as
first
you ex-
suspicion. Remember that the affidavit actually requires the deponent to state what suspicions that they harbor. The first is there in paragraph 2. On my reading, the second would be at paragraph 4.
Let's take it step by step. Do you agree that that's the first suspicion?
That is the first one.
All right, thank you.
Thank you, Chair. And paragraph 3, for purposes then of completeness, the deponent speaks to what became clearer to him, how his suspicion became clearer to him, but he adds nothing more. He references an envelope he says was slipped under the door of his office in Parliament containing some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So he tells you that I have that, but he doesn't share the contents
Yes.
of those. Yes. The second suspicion is reflected in paragraph 4. And on my reading, that speaks to 2 suspicions. The first being a manipulation of procurement processes and processes to appoint and promote certain persons within crime intelligence. That's at paragraph 4, the first part of paragraph 4. The second part is, calls for the need to investigate appointments at various Secret Service offices. Sorry. Do you agree with me? That's
I
all.
have that.
At paragraph 5, he expresses a suspicion that some funds are being taken unlawfully from the secret funds account and given to Police Minister Becky Cele. At paragraph 6,
Before you do paragraph 6,
yes,
This
Commissioner.
paragraph 5,
Yes.
did you consider it to contain 2 complaints? I mean, there's the first about money being suspected to be given to former Minister Cele, and then it seems to me there's a second leg to it, an allegation that the former minister appointed General Khumalo without an interview process and without Khumalo having worked as a, did you consider that another suspicion and complaint? Or did you not?
I will
And
check
I
in
must
the
say
number
before,
of
I must say
six. It
before
is.
you answer, I must say before you answer that considering how the Mukwele matter has gone,
Yes,
I expect that
that
you,
would have been one of, it's a separate
and
appointment
and
issue.
if you haven't, there has to be an explanation
Yes.
why this was not
No, it
investigated.
is part of other appointments.
Okay, so you will come back to us with the
We will
detail
come
of
back,
it. Thank you.
To you. And may I just pause just to indicate, Commissioners, at the bottom of paragraph 4, it is not separate, but there is reference in the last line, which we had to look at as we go through all of the matters, likely points to launder money. So the money laundering is an aspect to consider when you look at money flows that may run through the course of all of these. And they are not, it's not a standalone matter.
Noted.
Sorry, you say that one, and you are referring to the last sentence of 4.
Correct, Chair.
And you say it goes with what?
It would go with 2, which is the manipulating of procurement processes, and then with 5, which Council had pointed out about the taken unlawfully from the secret funds.
Which sentence are you referring to in 2? Sentence or sentences?
Sorry, paragraph 4,
Para 4,
line 2.
line 2. Oh,
Yes, Chair, about the manipulating procurement processes.
okay. All right.
Just to indicate that money laundering is considered, but not as a standalone, just within the ambit of those matters.
Yes.
Okay.
Thank you, Chair.
So,
When I interrupted, Council, I think we were.
no, it's okay.
Fine.
Just on the point you've made, it's a suspicion, but couched more in request terms, because he's requesting that you look into these matters, I guess, because these secret service offices in the country are likely points to money laundering out of crime intelligence. So in that, I can accept that there is a suspicion that there is money laundering, except that he would like IDAC to investigate whether that laundering happens through various secret service offices.
Correct.
Okay. Then we agreed that at 5, it's a suspicion about secret funds being given to the former Minister Bekitele.
Yes, ma'am.
6, I don't see a suspicion in 6, so I would skip it for now. We'll come back to 6. The last suspicion that he then highlights is at 7, at page 515. My suspicion is that General Khumalo Lushaba Madondo and many of those who they've appointed are actively siphoning money from the secret fund accounts in the country. I understand that there are about 10 secret fund points in the country where monies can be drawn from, and all of these extraction points need to be investigated. That's another suspicion. At 7.
May I take you back to 6, Council?
Yes, ma'am.
That is the Lushaba matter. And therein he has been charged not just with the housebreaking, but with the defeating and obstructing with regards to the loss of the equipment of crime intelligence and the non-disclosure thereof, and the fact that there's secret information contained therein. So what I'm saying is the 6 is the Lushaba matter that is currently in court.
Yes, I'd ask that we skip that because we are trying,
Only
to distill from
okay,
this,
then I
from the
understand.
affidavit what the deponent suspects and what
Okay.
suspicions he has put forward to IDAC. So we have dealt with the suspicion at 7. Then 8 and 9 basically reverts to the dockets he had opened, the 3 cases in Cape Town, and the other 3 in Orlando Police Station. And it ends at 516. So if we at least roughly summarized his suspicions, I can see how he has complied with Section 27A, which is to set out the suspicions of a crime that he complains of. I am missing Part B of that, which requires him to set out the grounds on which the very suspicions that we have referenced are based. Do you find the grounds in this affidavit? Per suspicion.
May I just raise an issue
Yes, Chair.
with you, which is a legal question with regard to, you are looking at ABC.
Indeed, Chair.
Okay, that's the nature of, I'm looking at the introductory part of the section itself. If any person has reasonable grounds on which I would not go to ABC without first ensuring that that introductory part has itself been satisfied. And that I would do on the basis that this is an objective test.
Yes.
You and I do not have to rely on what Mr. Adams
Indeed.
subjectively thought.
Yes.
So I would start there, were there reasonable grounds? But anyway, let me leave it.
My approach is slightly different.
So, but I'm just making.
Yes,
the point
I take the point.
I would not get to ABC before, but.
I take the point, Chair, that's an approach, but I decided to adopt a different one. Here is IDAC having solicited an affidavit,
Yes.
receives the affidavit.
Yes.
Before a decision is taken, even for a preliminary investigation, that affidavit must comply with at least ABC.
Yes,
And I conclude that the grounds advanced in terms of B would lead to the conclusion at the start of that, whether they are reasonable grounds. So it's sort of a reverse.
In the end, perhaps it works the same way.
Because I'm trying to test
Yes.
at which point, insofar as IDAC is concerned, a Section 27 referral dies
Yes.
for non-compliance, if ever there is such a point.
No, please go ahead, Ms.
Thank you, Chair.
Ms. Shalula.
Thank you,
Thank you.
So I'm now looking at 27B, and my reading of this affidavit is that it's replete with suspicions, but absolutely no grounds to support any of the suspicions advanced, unless you can find any that perhaps I may have missed. I adopted the approach I did to say, let's summarize and see if we can quantify the suspicions. So let's start with the suspicion at 2, that General Khumalo, Lushaba, Madondo, and other senior crime intelligence officers were busy with the systematic capture of the crime intelligence division. Let's just sit with that one suspicion. Where in this affidavit do I find grounds to support that suspicion, which then would tick A and B of Section 27?
So, first, in paragraph 2, line 1, Commissioners, he says, so the cases he refers to above must refer to what follows. And he says the cases were opened based on information I received from time to time, which places the SAP's crime intelligence, and then it follows. So he receives information from time to time. And he then says in paragraph 3 that suspicion became even clearer when an envelope pushed under his door at Parliament contained crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So the grounds on which he bases it is information he receives. Information he receives from time to time, and further expounded by the fact that he has this envelope with further information that is pushed under his door. That is the genesis for the grounds on which his suspicion is based.
But you said he did not give IDAC that information which was slipped under his door.
That is correct.
So that's like saying, I have grounds, but I won't tell you what they are.
May I explain a further process that then happened? Sorry, Council, may I?
Absolutely, ma'am. By all means.
Because it might seem to jump the gun, but it will then perhaps provide more clarity. We received the Section 27. We received the dockets. IDAC takes the stance that an engagement has to happen with Mr. Adams because this 27 he did on his own and sent through to us. We have the dockets, but when they had the engagement, having read the dockets, having read the 27, it goes back to what I said. You then engage the person to see if there is other grounds that need to be covered. And further statements, Commissioners, were then taken in the engagements had with him in January of 2025.
I think where we are, Advocate Johnson, is that 27 says these things must be specified in the 27 affidavit. Because if you read 27, it says, by means of an affidavit or affirmed declaration specifying ABC. So ABC are to be specified in the affidavit.
Correct.
They are not to be established at a later point. So the entry point is the affidavit which specifies A, B, and C.
And it is for those reasons, Commissioner Khumalo, that I referred to those two paragraphs. That is where I took that from, where were opened based on information I received from time to time and the information placed under his door.
If perhaps you may assist us then. The suspicion is General Khumalo, Lushaba, and Madondo and others are busy with systematic capture of the Crime Intelligence Division. That's the suspicion. You are satisfied that that affidavit contains grounds to support that suspicion. Can you summarize those grounds for us?
With reference to the affidavit itself, right?
Indeed. Thank you, Commissioner.
On my reading, Counsel,
Yes, ma'am.
that suspicion is, he refers to the suspicion and he proceeds to explain, as he does in paragraph 4.
And what grounds are articulated in paragraph 4?
Says that he suspects that General Khumalo and some senior officers in crime intelligence, including
I apologize. I thought we agreed that paragraph 4 contains other suspicions. I'm still looking for the grounds for the suspicion that Khumalo et al. Are busy with systematic capture of crime intelligence. Where are the grounds for that? The manipulation of procurement processes and processes to appoint is another suspicion. It's a different one.
Yes, and I'm saying that it is based on, I don't read it to mean that every single suspicion is supposed to have a ground. If my reading is incorrect,
No, not necessarily.
I'm saying that is how I read it. I read it as I received information from time to time. From that information I received from time to time, there are all of these allegations, inclusive of the documents under my door.
Okay. You wanted to invoke paragraph 4 to establish the grounds. Remember, we still have to comply with section 27B.
Yes.
So we're going to have to at least find the grounds for the suspicion reflected in paragraph 2. You say those grounds lie in paragraph 4. And if you could just summarize them quickly for us. And simply because my reading of paragraph 4 is slightly different, but I'll take your perspective.
So the suspicion of the systemic capture lies in his suspicions in paragraph 4 in terms of, he refers to the procurement, manipulation, for lack of a better description, manipulation of appointment processes, bypassing of the vetting. Those are the ones that talk to the systemic capture of the crime intelligence division.
He's not, in paragraph 4, and what you're referring to now, he's not giving you facts that support his suspicion, because that's what 27B requires, the basis for his suspicion. What he does in 4, on its terms, he says, I suspect, that which you're referring to now. He says, I suspect that General Khumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes and processes to appoint and promote certain members to higher positions. So it's a suspicion. So you can't say, when we ask you that, okay, he's made the suspicion to you, so let's say he complies with A, what are the grounds that he has stated in his affidavit in support of that suspicion? You can't say where he states manipulating processes, procurement processes and processes to appoint, and then you say those are the grounds. That's faulty reasoning. It is a suspicion on his terms. It is. He tells you, that's what I suspect. The question to you is, where in the affidavit did you find that he has put down grounds for that suspicion?
On my reading, Commissioner Baloy, it is found for those ones on paragraph 3, where he said, my suspicion about General Khumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. I can take it no further than that is my reading of where he finds these suspicions.
Factual conclusion after factual conclusion, Advocate Johnson, can never give you the facts that undergird those factual conclusions. All of the things you are addressing now are themselves factual conclusions. Do you understand what I'm saying? Do you understand what I'm saying?
If you could just take
those are factual conclusions. Let me
Yes.
give you, let me give you, agree? Do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So, if we go back to Ms. Sildo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand. You.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of Section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Ms.
Thank you, Chair. And then, following that very same approach to all the concerns, I'm going to put it broad. Where in this affidavit do you find any grounds that can potentially get anywhere close to Section 27B? And I put it that way because I'm talking to a lawyer of 30 years experience who appreciates that when a statute prescribes what jurisdictional factors must exist before certain outcomes are achieved, you would understand that they have to be satisfied independently of one another. It's first A, the suspicion, B, the grounds. Where in this affidavit do you find the grounds that would satisfy the requirements of Section 27B?
I have referred to those grounds and say that having heard what the chair has indicated, there's nothing more than just what he said here. It is a matter of, he says, this is what I have, information and documentation. I think the question, and sorry, Commissioners, I don't mean to be asking you all a question, but what I'm trying to pose for myself is, the question then is that sufficient for B?
Was there a sufficient factual substratum to satisfy B of Section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of
Yes,
it is.
the factual basis that undergirds or supports the factual conclusion.
Correct,
You've accepted that there was none.
yes.
Do you then accept on that basis, because my and your engagement had started on the basis of the first suspicion,
Yes.
which is state capture, would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
His conclusions.
his conclusions of, I have information, and I receive information, and I also had information. It is
Now-
on that basis, yes.
If that's where we land, would such an affidavit comply with the requirements of Section 27? And what would be the consequences of non-compliance?
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes, so on the basis thereof, Commissioners, I've applied my mind differently. The Commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes, I agreed that it fulfilled that requirement because he had knowledge. He had grounds on which it was based. I've given the answer, Commissioner. I can't change that answer.
Are you seriously telling us that since what, you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or
No.
IDAC's legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No,
oh, okay.
I'm not going back on the argument.
Okay,
I'm saying
okay,
in the way I've applied my mind, this is a reasonable suspicion
Yes.
that must be borne by a reasonable man and or person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But Adams...
Once, you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
Yes.
over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that. Yes. Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the section 27 on the test of the reason.
Subjective, it must be.
At the time, yes.
It must be, because that's what you believed. Hence, your answers on a few good times now during this engagement, your answers that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So
This one.
that means in your case, the word reasonable, which appears in so many words in section 27, did not come into the equation whatsoever. Is that so?
It does because
No,
of
it
the first
couldn't.
reading.
Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct?
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with
But-
the offenses, which was part A.
It's there fine and you are reading it fine, but what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said, on your understanding, the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Thank you, Chair. Based on the engagement you just had with the Chair, would it be a fair understanding that all your approaches to all Section 27 referrals you've had is the attitude you had to this particular one? So IDAC initiated investigations based on numerous of such affidavits which don't advance any grounds to support suspicions expressed therein. Has that been the case throughout the years you've been at IDAC?
No, ma'am.
And why then how have the other affidavits been dealt with? Have you interrogated their compliance with Section 27 before initiating an investigation?
Yes, the other affidavits were quite different. You'd also see, I think you requested from us the affidavit of a different witness. Yeah. When you read those as well, you can see the compliance with these sections.
Why didn't you bring to bear that particular need for compliance to this particular affidavit, which is dated less than 2 years ago, November 24? Why did you treat this affidavit as an exception to the rule that you say you had come to apply to all other Section 27 affidavits?
So I'm not going back.
Yes.
And I think that is where my fault line lay, is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error. The test isn't subjective, the test is objective. Here I brought a subjective mind to bear on the information the person gave us.
And Advocate Johnson, that is apparent from paragraph 4, because Mr. Adams says none of these people were suitable to be appointed to the post. That's his personal view, without grounds to support that.
Correct.
He doesn't even say they did not meet the minimum criteria, they did not have the qualifications. He just says, you appointed somebody from BMW as a brigadier, and then he says, not suitable, full stop. Why are they not suitable? Do they not meet the qualifications? He does not even identify the offense that he suspects is being committed there. Because appointment of somebody from BMW on its own does not tell you anything. Because my immediate question would be, what is wrong with appointing somebody, an engineer from BMW? If the position required an engineer, what would be wrong with that?
Correct.
That would be my immediate question. And I would need that to be addressed in the affidavit itself. Because the entry point, according to section 27, is that the affidavit must specify 1, 2, 3. Not that it must set out the suspicion and then the grounds IDAC will figure them out for itself.
Understood.
Just on an answer you gave in response to Ms. Sillo, you said an error that you committed was not to apply was to apply the subjective test. The test is in fact objective. In that response, based on the answers you gave to me, and repeating the same thing a good few times throughout until your engagement with me, the distinct impression I got was that you've always understood the test to be subjective. Correct?
I understood the test to be the reasonable person test, which is an objective test.
Okay, I will not go back. I engaged you on the subjective and so on because you cannot marry subjective and objective. It simply can. Oh, let me ask you this question. So throughout your understanding of section 27 was in accordance with the responses you gave when I engaged you. As to what those were, the transcript will assist us. Throughout, that was your understanding. It is only now that you have clarity as to what exactly the test is. That is a test which is not subjective as you suggested it was, or a test which does not seek to mix a subjective and objective test. It is simply objective. So before now, you had, I feel bad to have to use this word, but your understanding was this muddled view of what the test was, which muddled view came out as I engaged you. So that was your understanding until now, until during this engagement. Is that a fair suggestion to you?
It is fair.
Thank you.
Can I just say, Ms. Johnson, that even allowing for it was an error, you applied the subjective test because of your misunderstanding of the test that applies. Even on that, in this affidavit, insofar as 27B requires him to set out grounds, this affidavit doesn't set out any grounds. To say I received an envelope that has procurement matters, that's not a ground. It doesn't tell you anything about the contents of the envelope. For all I care, those procurement documents may well not demonstrate anything wrong. So it's not clear to me when you say, well, I accepted because he's a member of parliament who serves in the portfolio committee, that when he says he has an envelope that is sufficient. You surely must know and understand that for you to say this falls within our mandate, you need to satisfy yourself with whatever it is he's relying on. So I don't accept that what you say is an error on your part of applying the wrong test, that it explains what happened here. It doesn't. Even on that error, I would expect you, as you understand the section, it says he must set out grounds, and he doesn't. He doesn't. When he goes on to say 4 other colonels who qualified or who are employed in crime intelligence, none of them were suitable to be appointed in this post. It doesn't tell you anything about this candidate that was appointed. It doesn't. So it is clear in 27B that he does need to tell you facts. Subjectively, he thinks those facts meet the test, but you have to know those facts before you say, yes, our mandate is triggered. You must agree with me. I must be correct in what I'm saying.
I'm not about to disagree.
Okay, thank you.
Thank you, Chair. I see it's 12:59, but it'd be an opportune time to take a lunch adjournment. Thank you.
Thank you, Ms. Lilo. Let's adjourn and come back at 2 p.m.
Thank you.
1, 2. We are ready to resume. Please make sure that your cell phones are off. Thank you.
Yes, Ms. Silva.
Thank you, Chair. Chair, before we continue with the witness this afternoon, Advocate Johnson has made a request to us as evidence leaders, which request I table to the commissioners for consideration. Advocate Johnson has requested that we sit until 4, but may she be excused at 3 this afternoon. She's, as the Chair is aware, currently on medication following her illness last week. And I'm made to understand that the medication she's on is having some debilitating effect on her. So she has requested an early stand down today at 3 o'clock.
I confirm that, Chair. There was that communicated to me by Ms. Johnson. I communicated it to Ms. Sello, and that's where we are. Thank you.
Thank you, Ms. Silva. Thank you, Mr. Bodlani. We will adjourn at 3 p.m. then.
Thank you, Chair.
Thank you.
Ms. Johnson, then we have an hour to run through some of the issues we had wanted to engage you with on today. I hope you feel better tomorrow.
Thank you, and thank you, Chair.
Thank you. We had just looked at the affidavit and its compliance, or the lack thereof, with Section 27. So now we're at a point where you are in receipt of this affidavit. Can you take the commissioners through every step you took regarding this affidavit, any discussions you had, and with whom, until the point of the 6th of December, when you say you took a decision to refer the matter for a preliminary investigation? Thank you.
Maybe before you do that, let's remember earlier we discussed that after you received the letter from the minister's office, you then spoke to Mr. Perumal.
Correct.
Who then took it from there. Now, when Mr. Perumal, after you speak to him and he takes it from there, does he come back to you to say anything before we get to this point of the Section 27 affidavit?
Commissioner Baloy, what he does come back and say, the gist of which is, he has communicated with Mr. Adams. Mr. Adams indicated that he had reported these 4 dockets that we see in the letter. He informed Mr. Adams that as per IDAC, if you want IDAC to look at a matter, you would have to depose to a Section 27 affidavit. He told him it would be best if he maybe sat with a legal representative, told him where to find the provisions of Section 27, and for him to then, should he still be of a mind, to then depose to an affidavit. That is where that part stopped. And then on the 21st of November, we were in fact then furnished with the Section 27 referral, which is currently in the doc, at least part of the bundle.
Okay, thank you. Then back to Ms. Sello's question then.
Thank you, Commissioner.
Perhaps for my benefit as well, please repeat
Absolutely.
the
question was, we have just very quickly looked at the contents of Section 27 affidavit. And as I understand from the witness's testimony, she has seen it and perhaps has engaged with the affidavit. We are aware that on the 6th of December 2024, she took a decision to initiate a preliminary investigation based on the affidavit. So I would like her to inform the commissioners of the steps she took subsequent to the receipt and consideration of this affidavit up until she took that decision.
Thank you. May I find out if you will be dealing with his reason to suspect at some stage? I'm not pushing you there, not now.
Yes.
Has reason to suspect in 28(1)A at some stage?
Yes.
All right.
I intend to do so.
Thank you, thank you.
Chair.
Please respond to the question, Ms. Johnson.
Thank you, Chair. I received the Section 27 referral. Once I received the referral, I myself perused the referral. I then decided to give the referral to the team of Advocate Manilal. At the time, I can't recall where he was, but I gave it to the advocate in his team, which is Advocate Ramsamy. The purpose is, as was explained previously, that once you allocate it to a team, commissioners, they would then peruse, see whether there's sufficiency, what next steps must flow. Ms. Ramsamy, Advocate Ramsamy then perused the Section 27 and brought a Section 2813 application. And the purpose, sorry.
Can I just interrupt you before you speak to the purpose? You haven't said anything about Mr. Sissoko. Is it
That is
because
correct.
at that time he's not featured?
It's not featured, and because this was really, some of the 27s are really voluminous, and I like that two-mind approach. This was just a small document where I could quickly apply my mind. And I looked at it and said, let me give it to a team as we would then ordinarily do, because on the face of it, there were offenses that fell within the mandate. I gave it to Advocate Ramsamy, who then perused the Section 27. She realized that there were references made to dockets, and because we didn't have those dockets, the best way, instead of asking Mr. Adams to amplify the 27, as one would ordinarily have done, is to first get these dockets, because he's talking to allegations in these dockets, and he makes reference thereto. So in order to get those, sorry, Council.
No, please proceed. Never mind me.
No.
No, continue. I don't intend to interrupt at all. Thank you.
And in doing that, she applied for a Section 2813, which is a preliminary investigation, on the 6th of December. It was a mechanism, commissioners, for us to then have an authorized investigation in order for us to now determine where these dockets were. Bearing in mind that Mr. Adams has already alluded to the fact that in Cape Town, these dockets were no longer there. He makes allegations. But he then says he opened dockets in Gauteng. So there's no need for us to go to Cape Town. If you open similar dockets in Gauteng, we engage then with detectives in Gauteng. It would have been one of the investigators. It would either have been Mr. Perumal or Mr. Rapeso, who indicated that we need to write a letter to the head of the detectives in Gauteng, who was a Major General Khumalo. It is a formal approach in terms of acquiring those dockets. I did pen a letter under my hand to the Major General, indicating that IDAC was now vested with an investigation and would require the dockets as per the letter, which were the dockets that were referred to in the minister's letter and subsequently by Mr. Adams.
But by this stage, you have now made a decision that IDAC is investigating this matter. By the time you are now asking for dockets.
A preliminary investigation, yes.
Okay.
And a preliminary investigation, if I may, is it might pan out to nothing. That is why it is safer to have done a preliminary investigation, because not knowing what's in the dockets, it could be a futile exercise having a full investigation, using all of the time and resources, and find that actually it's insubstantial to support.
And you did this in terms of section 2813,
1-3, Chair.
section
Yes.
2813. All right, thank you.
Thank you, Chair. In the morning, I had understood that your approach to the head of detectives, I think you said General Khumalo.
Major General Khumalo.
Khumalo, was, requesting the dockets was on the 6th of December.
That is correct.
That is the same day a decision was taken to authorize a preliminary
That is
investigation. So it can be on the 6th of December that Advocate Ramsamy made an application, because you are only making a decision on the 6th of September to initiate at 2813 in preliminary investigation.
The authorization was dated the 6th.
That's your authorization.
My authorization. She would have given me the papers prior. I just can't tell you which day prior to the 6th.
What papers would she have given you in this regard?
So it is an application for an authorization, which the ID must consider to approve. So she wouldn't have given it to me on the day to approve on the day.
So at the time she gives you whatever application she does, what is she armed with?
She would have been armed with the section 27.
She also, at least she got a copy.
She had the 27.
Okay.
Yes, ma'am.
Now, I think it was yesterday or this morning, I came to understand, and maybe I was wrong in my understanding, that prior to the 6th, you and Mr. Sissoko, I thought you said, engaged extensively over this Section 27 affidavit, on the basis of which you then took the decision you did on the 6th of December. Now, in the narrative you just provided, you haven't said anything about your engagements with Mr. Sissoko.
The chair did ask earlier. I said in most of them, I would engage with Mr. Sissoko. This was a very small section 27. I don't have to give him. It is a practice I do, and usually with the more bulky ones, they have been on the off case or off chance where it's really a small, not small, it's not nice to say small. It might not be substantial, and I am able to go through it myself, apply my mind, and make a decision.
So are you suggesting my understanding all this time has been wrong, that you engaged with Mr. Sissoko on this particular referral? Because that's what I had understood from your testimony.
I didn't engage him on this referral.
It's not, Mr. Law, it's not a misunderstanding. It's what you said throughout, that you did consult with him. If you recall, even yesterday, when I said to you that Colonel Parayaki spoke of a committee, an intake committee, and you said, well, on paper we have it, but we haven't yet implemented it. And so what I do, this is what you said, what I do is I receive it, I consider it, I form a view, I give to Sissoko, and he then took that into account, and he came back to me, and we agreed that this falls within our mandate. That was your testimony yesterday. So it's not a case of misunderstanding, it's you are revising what you said to us yesterday.
Sorry, if I created the wrong I meant when we talked about the intake committee, I was trying to explain that there is no committee, how the Section 27s worked. So if I created that impression or it's incorrect, I did not share the Section 27 with Mr. Sissoko.
So too then was Colonel Padiachi wrong in testifying that the briefing was given to the team by Chief Perumal after the case management committee or what had considered the Section 27. That's utterly wrong.
No, that's wrong.
Because you are not a committee, you are one person.
We are not a committee.
Yes.
And sorry, Chair, I did indicate yesterday, there is no committee, and I cannot call Mr. Sissoko and I a committee. I give it to him because he's an investigator, and with me being a prosecutor, it helps that perspective. But there is no committee at the moment that deals with any of the 27s as they come in.
And it might be a speculation on your part, but What could possibly have led Colonel Padiachi to conclude that the investigation referred to the team was following a decision by a committee? What could have?
I think I alluded to yesterday that we're in the process of putting together a draft standard operating procedure manual. It is one of the things that is proposed in the manual, but it is not implemented currently or in effect.
Okay.
I think I did allude to that yesterday.
So, please have regard then to Section 27. Seeing as you are the person who received the Section 27 referral, who considered it, I think now at that point, the question the chair wanted to engage you on, is it correct to say that on your reading of that affidavit, you considered that there were reasonable grounds to proceed with this investigation?
Correct.
That's what you consider. On what basis?
So there were reasonable grounds for us to consider the matter based on the allegations made out.
Just the suspicions,
Just
and
the
nothing
reasonable
more.
suspicions.
And at that juncture, you had nothing but the Section 27.
That is correct.
And then if we go to Section 28:13, that section provides, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. So by this point, you had, based on just the affidavit, you considered necessary to hear evidence on these suspicions.
That is correct. And the hear evidence is not of necessity oral evidence. It's getting the evidence to support, if there is, in fact, to support those reasonable grounds.
But what do you make of the word here, open quote here evidence? What do you make of just that word here?
Is the conducting of the interview with the witnesses,
Okay.
prospective witnesses.
Okay.
And thank you, Chair.
And be a formal process, a recorded process,
It
those
can
interviews.
be a recorded process, yes. More often than not, the 28s are a recorded process, or it is an interview process,
Yes.
and then the statement is taken.
Yeah, but what I'm asking is, in what happened in that interview, there must be a record of it.
There should be a record of it, yes.
On this day, so-and-so met with Mr. Adams at Pretoria from this time to that time. This is what was discussed. Yes, it will culminate in a statement, but there is a record
There should be a recording,
of what
yes.
happened. Thank you.
Yes.
And you know this for a fact. We
no,
don't want you, we don't
I'm
want,
saying that is
sorry,
sorry.
just a minute. We don't want you going back on what you've just said in response to my colleague, Commissioner Baloyi.
I did say, Chair, there should be a recording. I will confirm that whether or not there was a recording. They
When you
must-
say,
they
when
should.
you say there should be, are you referring to this instance, or are you saying there should be a recording generally, as a general statement?
In these matters, generally, there is a recording.
So there is a recording.
A recording, yes.
As a matter of course.
As a
there
matter
is-
of course.
There is a recording.
Yes.
All right, all right. May I just ask one?
Absolutely, Chair. Thank you.
The section 2813 hearing of evidence, let me loosely call it that. Surely that the need for that does not undo the requirements of section 27. Section 27 must have been satisfied. The requirements of 27 must have been satisfied. You cannot, if the affidavit does not meet those requirements, you cannot get to 2813. Is that correct? Do you agree?
That is correct, Chair.
Thank you. So basically, as you would have learnt in your administrative law, those are the jurisdictional facts for, or to trigger anything that gets done under 28.
Correct.
Those are the jurisdictional facts.
Correct.
Thank you, thank you.
Just one from me. To hear evidence under subsection 13, do you have to summon the witnesses who are going to give that evidence? Do you have to issue a summons to Mr. Adams, for example? How do you hear the evidence in the absence of a summons?
There are oftentimes, Commissioner Khumalo, where you contact the person and they are prepared to come in, or where they do not want to come in, then you do issue the summons in terms of section 28.
So in this specific case, what happened?
In this specific case, Mr. Adams was contacted, he was prepared to cooperate, and the investigators and a prosecutor then went ahead to interview him.
Now it works. Now it works. Ms. Johnson, can we have a record of that section 2813 process that you say happened? Can we just have a complete record of that?
For this,
Yes, that 2813 process.
that would have happened with
Yes.
Adams in January.
Yes, thank you.
Thank you, Commissioners. So, I think earlier, oh, sorry. She's still writing.
Thank you.
You made a note. Okay. Earlier, you indicated that Advocate Ramsamy prepared the section 2813 application.
Correct.
We don't have a copy of that application. Are you able to provide one?
May I just check with my Advocate Marga if they didn't ask for the section 2813?
No, we
Is it
hadn't
not?
requested it in the subpoena. It's not one of the subpoena documents. So
But we
I'm saying,
request-
now that you
request
reference it, are you able to provide us with a copy? So then if I understand your testimony, you give an instruction to Advocate Ramsamy and the Section 27 affidavit,
Correct.
and you want Advocate Ramsamy to make an application back to you in terms of Section 2813. Please explain how that works.
I have applied my mind to the section 27.
Yes.
But I have to give it to a team to also apply their mind and to see whether or not an investigation can be instituted. I took the view at the time that it fell within the mandate of IDAC. But in terms of the prescripts, no investigations can happen if you are unable to comply with an application for an investigation. So we hand it over to the prosecutor, who must look at the 27. She didn't have to apply for a 2813. If she then, after having assessed it, decided it does not fulfill all the requirements. It is consider this matter, and if you agree that it falls within the mandate, we are all lawyers to apply our minds, then please lodge a Section 28 application. She decided to lodge a Section 2813 application.
You said the first part, you give it to the prosecutor and ask her to apply her mind to the Section 27 affidavit, and then express an opinion to you, and then thereafter she lodges an application. Is that correct?
Instead of an opinion, if you agree that it falls within the mandate, you then apply for a Section 28.
Okay. Where is that? Was that your instruction to her? here is a section 27 affidavit, consider it. If you agree that it at least discloses a basis for a preliminary investigation, please provide me with a section 2813 application. Is that more or less how
A
it
Section
goes?
28 application,
Is
yes.
that how it normally happens?
That is how I recall it happens, yes.
Did its Advocate Ramsamy ever express a view to you on the content and depth of the Section 27 affidavit? Did she ever express her views on that affidavit?
No, when she brought the Section 28 application, I realized that she agreed with the contents of the Section 27.
And she never expressed a different view that it's deficient, it doesn't comply? No, she didn't?
No.
She also didn't pick up the fact that it doesn't comply with Section 27?
No.
She didn't. Commissioners, yes, please go ahead.
This application, it's made in terms of what? Because my reading of 13, and it may well be that there's another section to read before I get to 13, but my reading of 13 seems to contemplate that you, for example, upon receipt of that Mr. Adams' Section 27, if you determined on the face of it that it is necessary to hear evidence, you would proceed to instruct that such a process should happen. Where do we see that Ms. Ramsamy had to make an application before that inquiry, that hearing of evidence could be held? I wouldn't have a difficulty reading 13 if you said, I looked at this affidavit and determined that we need to hear more, and then I authorized a preparatory investigation. I wouldn't have a difficulty with that because I read 13 to empower you to do that. But you speak of a more involved process where you make the determination that this falls within our mandate, you give it to somebody else for their opinion and execute, and then you say to them, if you think we must do a preparatory investigation, bring that application, and I'd like to see where is that contained, that step.
So I take it, Commissioner Baloy, from the section that I had referred to, which was the Section 2813, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. That is where we take it from.
No, I'm not questioning that you could convene the hearing of evidence, or you can convene a preparatory investigation or hold a preparatory investigation. I'm not taking quarrel with that. I accept that in terms of 13, you have the power. I'm just trying to understand this process that you've just described to Ms. Sillo, where you get the Section 27, you look at it, you make a determination that it falls within, what is raised there falls within your mandate, so you should investigate. And then you give it to Ms. Ramsamy, you give it to the team, I assume
Yes.
at that point to execute. But I understood you to say to Ms. Sillo that in that discussion with Ms. Ramsamy, you said to her, look at it, if you think it's necessary to hold a preparatory investigation, make an application. That's what I understood you to say.
Look at it and see if it is necessary to make a Section 28 application.
Yes.
Yes.
Then my question is, a Section 28 application in terms of what? Is this a practice? Is this one of those where in your office, you have ways of doing things. I mean, you have encountered these subsection 13 many, many times. So if it was in the Act, I think if that requirement to apply to you, if it was in the Act, I would have expected you would go straight to it because it's something that you encounter every day. If you are not able to find it, can we conclude that this is one of those instances where you practice things, you have ways of doing things, they're just not written down?
That are procedural based on the requirements of what would initiate an investigation.
Yes, so it's not written down anywhere, you just have a practice in the office?
It is a practice, yes.
Thank you.
Both 27 and 28. So if you look at the main body of 27 and 28.1, because those are the two sections that take you to 28.13.
Yes.
For you to determine that what is reported to IDAC falls within your mandate, there must be a reasonable suspicion or reasonable grounds to suspect that a specified offense has been committed. So in what was presented to you, what is that specified offense that you looked at and then said this falls within our mandate?
In terms of the 27?
Both 27 and 28, because that's where you start.
Yes.
Chair has engaged you on the test, subjective, objective. We've moved past that. Something further must exist, and that is a suspicion that a specified offense has been committed or is being committed, or there's an attempt to commit such an offense. So what is the specified offense here that made you believe that this falls within IDAC's mandate?
It would have been where the procurement portion was. It was contraventions of PFMA and or fraud, where the siphoning of the monies and or that was the theft and the financial crime with the money laundering aspect, and where the issues of the vetting and the appointments, it was in the way that it was couched, the capture of those systems and processes.
So are those specified offenses as contemplated in 27 and 28?
Those are the offenses as set out in Section 7 of the Act that set out the offenses that IDAC falls within IDAC's mandate.
No, that's a different question. 27 and 28.1 do not say any offense, unless you read specified offense in 27 and 28.1 to mean any offense referred to
in Section 7.
In Section 7. Is that how you read it?
Yes, because we have no other offenses. That specified offense is the one that was deleted, and they didn't.
So let's just be clear then. So your determination was that because these offenses are offenses referred to in Section 7, sub 1, capital A, that is good enough.
Correct, Chair.
Even if they are not specified offenses as contemplated in this statute.
Yes,
as far as you were concerned, you still had a mandate to investigate them.
That is correct.
And that was your understanding?
Correct.
Okay.
Thank you, Commissioners. And you then subsequently received, I take it, the Section 28.13 application from Advocate Ramsamy, and then you authorized the preliminary investigation.
That is correct.
On the 6th of December. And prior to your authorization, is there any investigation that Advocate Ramsamy or member of her team undertakes? Or does she apply her mind to the Section 27 affidavit and perhaps the law, and then drafts the application in terms of 28.13, meaning she doesn't seek to obtain documents extraneous to the affidavit?
Correct.
So she works purely on the affidavit?
That is correct.
And forms a view?
Correct.
Okay. Now, this morning, As I think Mr. Bodlani indicated, documents were forwarded to the commission as part of the subpoena requests made. And these have been received, we confirm. In a moment, we'll be turning to them. Yes, no, I hadn't. I said I will be referring you to something. The commissioners will recall that this morning I referenced documents that were requested. Yesterday I indicated that they had started trickling in. And Advocate Johnson read off some documents she had at hand, and she indicated that they've been provided to us. And Mr. Botlani confirmed that. The documents have been received, and I'd like to, they should be included in your files. I pray they are. We are now in file 8. And I'm interested in particular.
Should we put away those we were using this morning? Or not really?
Judging
Not
by the
at-
time, yes, I think so. Considering we're ending at 3, yes.
Because there's quite a clutter in front
I
of us.
can well imagine. I apologize. Yeah, except for the file containing the referral affidavit, file 2, page 512. Thank you, Chair. Thank you, Commissioners. In particular, I wanted us to go to page 3282. That is the authorization in terms of Section 28, sub 13 of the NPA Act. Advocate Johnson, I need us to put a finger on that page and that file. Please don't close it. And let's go back to the referral affidavit. That would be file 2, page 512. Now, in this affidavit, I note at paragraph 2,
Sorry, 512.
512 of file 2. Help is coming.
This is file 2. Why do we not have
Page 512.
I don't know why.
The referral affidavit.
Yes,
Yes.
I had given the file back. I'm not sure why I'm not seeing it.
Did you perhaps, because of the clutter around you, did you take it out of the file?
No. No, I didn't take it out of the file. File 3.
May I request your counsel to, I don't know how many copies they have available, of the referral affidavit, page 512 of file 2. And for your purposes, Mr. Bodlani, we will be flighting it, so you'll follow it on the screen, if you could. Thank you so much.
Apologies. Thank you, Council.
My pleasure, Member. Now, if we go to paragraph 2, on this affidavit, I see concerns regarding General Khumalo, General Lushaba, General Madondo. You see that?
I see that.
And overleaf at paragraph 4, that's the suspicion regarding manipulation of procurement processes. At second sentence of that paragraph, I see it says, I suspect that General Khumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes to appoint and promote certain members. You see where I'm reading?
Yes, ma'am.
If we drop further down in that paragraph, fourth line from the bottom, once again, it speaks of persons being appointed to strategic positions, and that such persons are suspected to be loyal and close to Khumalo, Lushaba, and Madondo, and those close to them. I go over leaf at 5. I see reference to General Khumalo, where an allegation is made about the former Minister of Police, Minister Cele. And as we know, paragraph 6 concerns General Lushaba and the theft that occurred at his home. Paragraph 7, once again, it's Khumalo, Lushaba, and Madondo. And I think that's about, then we get to paragraph 8 and 9 and 10, which are concluding paragraphs of that affidavit. You confirm that?
Correct.
Now, this is the same affidavit that Advocate Ramsamy was armed with.
Yes.
Now, let's get back to our file 8, page 3282.
Got it.
Now, at 3282, that's an authorization signed by you. If you look at 3283, it's dated the 6th of December, 2024.
Correct.
And in the first page, you say, I, Andrea Johnson, and you continue regarding your authority. And you indicate that you have reason to suspect that the following offenses have been committed, and you list them. Am I reading your authorization correctly?
Yes.
So these are all the offenses?
Yes, all the possible offenses.
Possible offenses?
Yes.
And you clarify that over leaf at 3283, where you state that these have been committed or are being committed, or attempts have or are being made to commit such offenses in an organized fashion by inter alia, the persons or entities in the annexures to be the institution of the investigation in terms of section 2813 of the Act in relation to the activities of South African police services and crime intelligence and any other entity. My question is, that conclusion you draw, that litany of crimes has been committed or being committed or attempts have been made, that can only derive from the Section 27 affidavit.
Correct.
What in the Section 25 affidavit leads you to the conclusion that the crimes listed in there, all or any, have been committed or were being in the process of being committed?
The Prevention and Combating of Corrupt Activities Act falls within the ambit of the allegations in paragraph 4.
Paragraph 4,
Yes.
noted.
not knowing what all would have happened in the alleged placement and appointment of persons. So you couldn't rule out the corruption. The Prevention of Organized Crime Act would relate to paragraph 4 and likely points to the laundering of money out of crime intelligence.
Yes.
The National Strategic Intelligence Act would relate to the vetting issues.
Okay.
And the Secret Services account relates to the allegation of paragraph, at the end of paragraph 3, the use of secret funds, and then there is the further allegation in paragraph 5, some of the funds became taken unlawfully from the secret funds account. So wherever there was a relationship with the secret funds account, that act becomes applicable. The procurement fraud, the alleged procurement fraud under the Public Finance Management Act, the Financial Intelligence Center Act also relates in part, just want to get there. To paragraph 7.
Yes.
And then the contravention of the Police Act because of the appointments and the vetting that is referred to. And then the allegations of fraud, theft, forgery and uttering and or defeating, obstructing the administration of justice, which would relate in part to, not in part, in the main to the charges against General Lushaba.
Okay, now, what would be the theft? What would relate to the theft here?
The theft was the actively siphoning money from the Secret Service account.
Okay.
And then there was the one...
and the forgery and
I
uttering?
suspect that funds became taken unlawfully from the Secret Service funds account under paragraph 5.
Thank you. And the forgery and uttering?
That would have been in relation to manipulating of the procurement processes and processes for the appointment, that there could be allegations there of forgery and uttering.
How do we start with manipulation of processes and then we suggest that there was forgery or that manipulation involved forgery? Because the process could have been manipulated in so many different, 1,000 ways. How do you land on forgery and uttering?
It is a possible offense.
Okay.
Yes. No. So perhaps, if you would allow me to just say, is that these are the offenses that one is looking at. They are not open nor are they limited in terms of you go with what you have, but if you don't put in the possibility, usually when you have fraud and or theft, there often does happen to be forgery and uttering. And so if you haven't listed that offense, it might become a challenge later on.
So this is a list of all possible crimes
Within the ambit of the 27.
of the 27?
Yes.
And you so maintain?
Yes.
Okay.
Please define forgery.
It is where, in terms of, for example, with the documents, that someone would have forged someone's signature either in the procurement documents, in the appointment documents, or in the vetting documents. It purely relates to the forgery in terms of putting in.
And there was a basis for suspecting that this had a reasonable suspicion that this had happened?
Reading it in its totality,
Would there be a reasonable suspicion that this had happened?
correct.
On what basis?
That if
Is there anybody who ever suggested that documents had been forged? For example, that certain people had signed documents purporting to be other people?
that has come afterwards in the investigation, yes.
Yeah, the question is,
In this
at
instance,
this point, when
yes.
you're writing this document,
Yes, that,
what were you relying on to get to the point where you say forgery and uttering is implicated?
I read it, Commissioner Baloy, in paragraph 4, where we talk of the manipulating of procurement processes and processes to appoint and promote certain members to higher strategic positions within the crime intelligence, that in that manipulation, there can be fraud, forgery, or uttering.
Speaking for myself, I don't see how that takes you to forgery. Remember, you've said in the introductory part, before you itemize the offenses you referred to, you have said you have open quote reason, close quote, to suspect. I don't see the reason for you to suspect in what you've said thus far. I just do not.
I take your point.
Thank
This is
you.
what I've got.
Thank you, thank you.
Thank you, Commissioners. Then just to conclude, at 3283, having then itemized those crimes, you say those offenses are being committed or have been committed by, I'm reading the second line, persons or entities in the annexure. Now that annexure appears at 3284, overleaf. That's the annexure. Now, we have General Khumalo, the General Madondo, General Lushaba, and a list of others. I know, as I indicated to you, that the Section 27 affidavit specifically identifies General Khumalo, General Madondo, and General Lushaba. We just did that exercise at the various paragraphs 2-4. I cannot find in the Section 27 the persons identified under items 4 to 12. And you recall that your testimony was, all you had at the time was the Section 27 affidavit. Does not reference any of the people listed from 4 till 12. Where does your annexure get them from?
Johnson, I think the question is, who gave you these names? They're not in the affidavit. We can look at it for the next hour. You will not find the names in 4 up to 12. Somebody gave them to you. Who gave you these names? And under what circumstances?
This application came to me from the prosecutor.
So Ms. Ramsa May will have to tell us where she got these names from.
That would be correct.
Okay.
Did you inquire from her where she got the names from when you know that you only gave her the Section 27 affidavit and you are quite familiar with it?
Yes,
Do you engage and say, who are these ones now? Where do they come in? How do they come in? They are not in the affidavit. You are not conducting an investigation yet, so you are not obtaining your own evidence. Where do these names come from? Did you have that engagement with her?
I didn't have that.
Why not? Shouldn't you have? Because from what you are suggesting, it's like she looked at those 3 names and said, no, 3 is not a good number, I prefer 12, and start like somarkhoying other names in there. And you signed, and you are happy with that. How come?
As I indicated, according to me, she only had the 27.
Yes.
And she would have then put together the 28.
Yes,
Yes,
which we're looking at.
yes,
And you know the 27 doesn't contain the names from 4 to 12.
that is correct.
So why do you sign it in the form that it is, where suddenly it includes a litany of other people who are not mentioned in 27 affidavit?
Brigadier Makwele is there, sorry. Council, you refer to only the first 4?
The first 3,
First three.
The first 3.
yes.
Sorry, Commissioner Baloy, that I'm now a bit slow. And I don't intend taking the whole afternoon to.
Well,
Sorry,
I'm just trying to be helpful.
I know,
Because
I'm trying to figure out how she would have arrived at the names because their official capacity is mentioned, but the names are not mentioned. I take the point.
you accept that it is not from the
27.
Section 27
Yes.
affidavit that she
Yes.
got the names?
Yes.
You accept that someone must have, if they come from her, someone must have given her these names?
Correct.
Yes.
And I will find out.
And you accept that at this point, when she approaches you with this application, the investigation hasn't started yet. You
That
gave her the affidavit, she looked at it, and she came back to you
That is
and said, we need to have a preliminary investigation. So you accept at this point, there's no investigation yet.
Correct.
All right, thank you.
My challenge is this, Advocate Johnson. You are authorizing an investigation into 8 people who are not mentioned in the singular document you have. They are not referred to you. There's no complaint regarding them. But you are authorizing an investigation into them. In terms of what section are you acting in so doing?
A conversation must have happened
With who? That's the question.
with Advocate Ramsamy.
No, she's not conversing by her soul self. Who is she conversing with?
What I'm saying is, she and I must have had a conversation.
Oh, so you are aware of
I'm
them?
saying she and I must have had a conversation, and I will follow that up, because I don't have an independent recollection of a conversation. And she would have to indicate then if she had a conversation with somebody else. I wouldn't just have blindly signed it without finding out from her.
Did you perhaps suggest these names to her?
No, these are not people I know.
Can I say that the difficulty is that you don't seem to abide the terms of this Section 27. Even if she proposes the names to you, you are the final decision maker, you are the in charge. You're the one that's authorizing an investigation. It's difficult to conceive of a situation where she comes back to you and she gives you a list of names and you don't say, no, we can't do that because it doesn't arise from this affidavit. We haven't started an investigation, so I know you didn't get those names from an investigation. I know you didn't do that. We have at this point only this affidavit. And you don't say, we are obliged to work with what we've got. We can't do whatever we feel like. It's difficult to understand that you would be party. If this is her giving, she gave you these names, that you are happy to sign off a truly invasive investigation, because your powers to hear evidence means you can call these people, you can look into their affairs. That's what it means. And you do it outside the corners of the only document you have on which you could work with. You, the head, are not in a position, and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you. At this stage, this is a misuse of powers to take intrusive steps and action against people on this affidavit. You have no justification whatsoever on this affidavit to be looking into Likalakala, Ncube, Moyani, Sibula, Madileng, Mokwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that. When in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. It's to me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
No, I have no comment, Chair.
Thank you.
Advocate Silo, you can clarify it, or Advocate Johnson can clarify it. Maybe I'm too slow now. Before this authorization, I thought there's an application, then the authorization, or does the application come after? Or maybe you can answer.
Yes,
it.
yes,
I had
because
understood that what should
understand both.
precede this authorization is an application.
That is correct.
Then this authorization authorizes the application.
That is correct.
Now, can you show us where that application is? Because it
So it's
may be
not-
that the questions you are being asked, the names were in the application.
I say that it's not part of, I don't see it here. And I will ask that they make the application available.
Okay.
I'm not sure why the application is not with the authorization.
The one that I see here, I suspect you're going to be dealing with it later, so I don't want to go
Yes,
there.
that's a different authorization
Yes,
now.
yeah.
Yes, it's not the 2813 authorization. Thank you. Chair, it's 15:02, as I'd indicated.
Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.